there's a cosmetic provision, etc., which says X should happen and Y should happen. But ultimately, what is the ground effect of the law? That is what is to be tested. Whenever there is a complaint to the court that some constitutional or other provision is being infracted. But effect of the law. Menaka Gandhi. So, yeah, so I will cite that. Should I cite it right away?
Just give the list.
Yeah, I'll give that list and I'll give you the paragraph and I'll read that one passage, for example.
Yeah.
So it's effect of the law. Now, what you will find, just to answer this point, is maybe I'll just deal with it right away. So, Your Lordship may just note, since we are on it, that the citation for Menaka Gandhi, you may just note, is 1978, 1 SCC 248.
Paragraph, you can just give the.
Yes, assistance, according to me, will be paragraph 19, last part, and I'll just give you the page. Page 299.
We'll go through it.
Yes, I'll just read well, the 10 lines, which I'll just read.
The passport.
Sorry? Yes, the passport. Correct. So I'm on the relevant portion that I'm relying on. I'm relying on 2-3 other paras, 16, 19, and 20. But I'm just now relying on, I'm reading just now 19, part of 19 on page 299. The majority took the view that it is not the object of the newsprint policy or its subject matter which is determinative, but its direct consequence or effect upon the rights of newspapers. And since the effect and consequence of the impugned policy upon the newspapers was direct control and restriction on the growth of circulation of newspapers, the newsprint policy infringed freedom of speech and expression and was hence violative of Article 19(1)(a). The pith and substance theory was thus negatived in the clearest terms. And the test applied was as to what is the direct and inevitable consequence or effect of the impugned state action on the fundamental right of the petitioner. It is possible that in a given case, the pith and substance of the state action may deal with a particular fundamental right, but its direct and inevitable effect may be on another fundamental right. And in that case, the state action would have to meet the challenge of the latter fundamental right. The pith and substance doctrine looks only at the object and subject matter of the state action. But in testing the validity of state action with reference to fundamental rights, what the court must consider is the direct and inevitable consequence of state action. Otherwise, the protection of fundamental rights would be subtly but surely eroded. So the point being made is, by all means, look at the rules. And I'll have something to say on the rules as well. But ultimately, you had a 2009 Act, and there was a very abysmal state of affairs. You now have a 2017 Act along with the rules. And that state of affairs continues, even though there may be some window dressing in the sense they'll show you some photograph. They didn't contradict any of our specific, I showed you one report, but we have reports for each of the years which we placed on affidavits by way of IAs, etc. No one says that this event was never held. No one said that it wasn't held in this or that these particular, those statistics which were startling as to the number of injuries which are considered, the number of deaths, etc. They're all startling and they remain, at least as far as I can tell, completely uncontradicted. So this is now one thing. Now, Manoj, may I just pick up the thread? And I want to just pick it up with the observation which was made by Justice Bose yesterday. Now, the observation was in the context of Madan Mohan Pathak. So I want to just cite that judgment, give you one paragraph. I'll like as yesterday, I'll summarize the facts and just tell you. So Madan Mohan Pathak is a decision of 7 learned judges. It is reported at 1978, 2 SEC, page 50. And I'll just indicate what happened over there. The Calcutta High Court had issued a writ of mandamus. And the mandamus was in respect of payments being made, etc., pursuant to a certain settlement, LIC. There was an amendment, there was an act to the, there was an amendment by which the effect of this was taken away. What our court held was, and this has been now, your lordships know, Madan Mohan Pathak has consistently followed, that a mandamus cannot be undone through legislation. That's a very, very important principle. A mandamus cannot be. And the relevant paragraph is paragraph 9 at page 67 of the SEC report. And here again, your lordship, we've given, of course, the citation, but I'll just read those 5 or 7 lines. Here the judgment given, it's on page 67. Here the judgment given by the Calcutta High Court, which is relied upon by the petitioners, is not a mere declaratory judgment, holding an impost or tax to be invalid, so that a validation statute can remove the defect pointed out by the judgment, amending the law with retrospective effect and validate such impost or tax. But it is a judgment giving effect to the right of the petitioners to annual cash bonus under the settlement by issuing a writ of mandamus directing the Life Insurance Corporation to pay an amount of such bonus. If by reason of retrospective alteration of the factual or legal position, the judgment is rendered erroneous, the remedy may be by way of appeal or review. But so long as the judgment stands, it cannot be disregarded or ignored, and it must be obeyed by the Life Insurance Corporation. We are therefore of the view that in any event, irrespective of whether the impugned act is constitutionally valid or not, the Life Insurance Corporation is bound to obey the writ of mandamus issued by the Calcutta High Court and to pay the cash bonus for the years so-and-so 75, 76 to class so-and-so employees, etc. So a mandamus cannot be undone. Now, a mandamus as now, so I'll just build on this on the point which the question which came a little earlier. Please note, this is not a case of a validation statute which has taken away the basis. This is a case, I would argue, even if we are wrong on everything else, this is a case this is an act operating on and from 21st January 2017 insofar as Tamil Nadu is concerned. So it is not seeking to validate and remove the basis as erroneous of the past at all, the finding standard, and that is correct actually, because the state government ought not to have done anything to undo the judgment. Now, having said this, let me just state the point on the mandamus, etc. And then, mandamus is, as your lordships are fully aware, take two states. First, it is order and direct A, B, C to do this. Second alternative is forthwith forbear from doing A, B, and C. I mean, this is basically positive or negatively styled. Now, please look at our judgment, the Nagaraj case, and just see the mandamus. Please go directly to paragraph 90 first, and you will find paragraph. So let's see the mandamus, and then we will just see how this is to be read. So it's at page 601 of the report.
Just 1 minute.
Yes, certainly. So, of course, there were the general arguments on separation of power, but now this is a very specific argument. If there's a mandamus, it has to be obeyed, it can't be undone.
Possibly the argument of state would be
Yeah,
that the foundation on the basis of which
yeah,
Nagaraj found the
yeah,
particular acts to be cruelty to animal,
yeah,
those were being removed
yeah, but
through the amendment and the rules.
right.
Possibly that would be the state stand.
I think that's right. Your lordship is correct. So that kind of cosmetic removal by amending some definition and putting an exception clause here and there is not going to help the state according to us, because what is inherently cruel remains inherently cruel and you can't undo it.
No, because
sorry.
some forms of cruelty have been retained by this PETA itself, like slaughtering animal for religious purpose.
Correct. I'm not by the.
So here legislature has chosen to decide which part of cruelty should be prescribed
Yes, you're right.
and which cruelty should be permitted.
Right,
So here, to what extent we interfere with the legislative exercise
right.
and interfere into their power to categorize which part of cruelty would be permissible, which part of cruelty would not be.
I agree. I will endeavor to answer that. That's important. So now just have a look, if your lordship would, at page 601. Please go to, page 601 of the report. So just have a look at paragraph 90. We therefore hold that AWBI is right in its stand that Jallikattu, bullock cart races and such events per se violate sections 3, 11(1)(a) and 11(1)(m)(2) of the Prevention of Cruelty Act, and hence we uphold the notification dated 11/7/2011 issued by the central government. Consequently, bulls cannot be used as performing animals either for Jallikattu events or bullock cart races in the state of Tamil Nadu, Maharashtra or elsewhere in the country. So this is a mandamus as we understand it. So apart from all the general arguments we have made, this is specific. You will forbear from allowing bulls to be used for the various reasons which we have given. Then what it does in the operative directions is, so it issues this declaration, it issues this forbearance in 90, and then it expands it, the operative directions in para 91, it goes to a larger scope to the 5 freedoms with regard to animals, and your lordship will say, therefore, will see therefore, that as far as the directions which are subsequently contained, 91.35, etc., are more generally worded, not just confined to bulls, but for animals more generally. So that is something which your lordship should do. Now, since we are 91.3 and 91.5 are also very specific on this in terms of the mandamus, governments are directed to take appropriate steps to see that persons in charge or care of animals take reasonable measures to ensure the well-being of animals. And 91.5, so-and-so is directed to ensure that the provisions of section so-and-so are scrupulously followed, meaning thereby that the person in charge or care of animals shall not incite any animal to fight against a human being or another animal. Now, this is a very general direction which is being given. And I don't believe, so this, anyway, I've made the point, which is that this deserves to be followed right through. It can't be undone. And you may just note, since we are on this, in paragraph 24, para 24 of the same judgment, which is at page 578. (23) and 24. Now, this is before the judicial, so I should mention, the judicial consideration comes later on in the judgment. But 23 and 24 at page 578, after seeing all the facts before them, we have also perused the recent affidavit of Srimati Uma Rani, the Secretary AWBI, MOEF Chennai, on 7th of April 2014, giving the details of the manner in which Jallikattu was conducted in various parts of Tamil Nadu, like so-and-so, etc. And the torture and cruelty meted out to the bulls, which is unimaginable. We notice that situations in the same is the same in Maharashtra. The details furnished in the second by the second respondent in IA, along with photographs, depict the state of affairs, which is also cruel, barbaric, inhuman, and savage. The report highlights the manner in which it is being conducted, and then it goes into further details. So this is the factual context in which it was held: barbaric, torture, cruelty, unimaginable savagery, etc. So, beloved, that is something which the court will keep in mind. So, our point, therefore, is that this is a completely colorable legislative exercise. Now, I've left that alone. Now, I come to my second point. Now, I'm done with that. I will, of course, answer your lordship's question on the larger issue regarding the legislative carve-out. Now, it's possible, and particularly with your lordship's deep understanding of various facets of animal anatomy, etc., when the question arises, would a larger bench, because your lordships are sitting in a larger panel now, and the question arises as to whether it would be at all prudent to overrule. So I'm on two. One is legislature can't do it. Now I'm done with that point. The question now is there an occasion to overrule as far as Nagaraj is concerned, even though it has survived the review scrutiny? My respectful submission, so I'll just state the point and then I'll just give you a couple of judgments. My respectful submission is that as far as precedents, and as not precedential value, but as far as final determinations by this court are concerned, which have attained finality, they ought not to be overturned except in certain narrow situations. What are those narrow situations? The first, which your lordship has noted, is if it is per incurium. And per incurium, at least on my understanding, would be without knowledge, say, of a certain statutory provision, of a certain binding precedent, and things of that nature. That is not the case here at all. The Nagaraj case is exhaustive, looks at everything in terms of international law, local law, very, very pertinently, constitutional provisions, notifications, statutes, etc. And therefore, it is not passed in ignorance or without notice of any. So that whole per incurium element, according to us, fades into insignificance. And then, of course, there was a review element also, which it survived. The second grounds which your lordships have said is that, look, there may be certain situations where there is manifest injustice. And manifest injustice is caused because, for example, I mean, this is a case which your instance which your lordship, where, for example, natural justice in its most basic element is not followed. Then that becomes the party is not heard, notice is not given, etc., etc. Then the binding, then there may be an occasion for the court to feel that if there is such a patent miscarriage of justice, then we will overrule the decision. A third category is that if there are certain procedural safeguards which are allowed over there under the law, but those procedural and other safeguards which are fundamental in nature were not comported to when the earlier decision was rendered. So these are the type of categories of decisions, very narrow, rare cases where a decision is overruled. So this is, Manoj, essentially my point. There are two decisions that I want to cite in this regard. The first one, my lords, is a judgment of Justice Sawant, and the report is at 1993, Supplement 1, SCC, page 96. And the paragraph that I am relying upon is paragraph 85, which is at page 145 of the report.
The page of this.
Sorry, the page itself of the citation is 96. It's 1993, Supplement 1, SCC, page 96. I think it's 96 and then the SCC report is 96 into brackets 2. The relevant portion is in para 85. Your Lordships have this Kaveri water disputes case?
Number 2.
Yes, number 2. Correct?
Number 1 and 2.
1 and
2 is a reference.
Reference. That's part of it. That's absolutely correct. Now just see the concise manner in which our court, sitting again in a constitutional bench.
This was that interim order controversy.
This was, Manoj, on
Whether it had power to issue the interim order.
this was, Manoj, on the reference.
All of this has been considered in the natural resource reference also.
Yes, you're right. You're correct. Correct. So the portion I am relying upon in para 85 is about a few lines down. The decision of this court on a question of law. Your Lordship has it. The decision of this court on a question of law is binding on all courts and authorities. Hence, the said clause. Hence, under the said clause, the President can refer a question of law only when the court has not decided it. Secondly, a decision given by this court can be viewed only under Article 1, reviewed only under Article 137, read with Rule 1 of Order 40 of the Supreme Court, Rules 1966, and on the conditions mentioned therein. When further this court overrules the view of law expressed by it in an earlier case, it does not do so sitting in appeal and exercising an appellate jurisdiction over the earlier decision. It does so in exercise of its inherent power and only in exceptional circumstances, such as where the earlier decision is per incurium or is delivered in the absence of relevant or material facts, or if it is manifestly wrong and productive of public mischief. See Bengal immunity. Under the Constitution, such appellate jurisdiction does not vest in this court, nor can it be vested in it by the President under Article 143. To accept Sri Nariman's contention would mean that the advisory jurisdiction under Article 143 is also an appellate jurisdiction of this court over its own decision between the same parties, and the executive has a power to act, to ask the court to revise its decision. If such power is read under Article 1, is read in Article 143, it would be a serious inroad into the independence of the judiciary. So the point which we try to encapsulate here is it per incurium, Nagraj? The answer according to us is no. Is there the absence of material facts? The answer is no. All the facts were considered correctly. And is it in any manner manifestly wrong? We believe not. And finally, is it productive of public mischief? The answer is also absolutely no. So therefore, there is no occasion, we would respectfully submit, for Nagraj to be overturned. I have to still answer your Lordship's question with regard to the subsequent statute. No, I accept that.
I have another question apropos to your submission.
Yes, of course. Of course.
Because there are many cases where the fundamental basis of an earlier decision
Yes.
is later on overruled by a bench of higher strength.
Yes.
Say the tribunal Sampath Kumar case.
Yes. You're right.
Chandra Kumar
Yeah.
overruled the fundamental basis. It was not a par incurium, it was not a public mischief.
Yes.
But
It had to do with the design of the constitution.
Yes.
What remedies are available under the, what's the constitutional architecture for redress?
Or for that matter, Golaknath and Keshavananda
Yes,
and Shankari Prasad earlier.
I agree. But
These are all fundamental basis of the judgment.
I agree with you.
Has been altered
Correct.
by later on by a bench of larger strength.
Yes.
So it's not that these procedural aspects solely form the basis for alteration of the earlier view of the case, but substantive provision or other substantive reasoning
Right.
also can be altered by a larger bench for whatever reason.
So there, I would suggest to the court that I would suggest two on the formulation which comes from the court. I would suggest two. There are two responses that I have. The first response that I have is that since certainty, predictability, insofar as a decision of a final court is concerned, are elements of rule of law, there is a restraint on a larger panel and a larger judge. I'm not saying you can't do it. Of course you can do it. You're sitting in a larger panel and therefore this is a self-corrective machinery as the court is correctly observing. But even that self-correction in our respectful submission is not attracted in the facts of this case.
Retrogressive.
Yes.
It would be retrogressive.
Yes, it would be definitely extremely retrogressive. It would be retrogressive for sure. That is certainly your lordship is correct to that is our submission. But in any case, I would submit, and I would like your lordships to also. I'll just hand over the. I shall not hand over. I'll just give your lordships the Antule case citation also. 88-2 SCC page 602. So now that was a case which had come up inter partes because this is also in a manner of speaking inter partes. So Antule is 88-2 SCC 602. Yes.
See, the bulls have been domesticated.
Yes.
So they are not performing, they're not adapted to fighting. Their cousins living in the jungles. You have got some material. It seems as they particularly fight over the cows.
Yeah, that's true.
Now,
We have a judgment of our court on the wild buffalo.
That's right.
In
You have seen it in the documentary.
Right, yeah.
See that how vicious they can get.
Correct.
The fight.
Oh, I think that's quite right.
So when you say domesticated, there is one significant feature here.
Yeah.
Taking on what my learned brother Roy said.
Yeah.
Part of tradition, culture, and they have a case that these bulls are specially rare in such a manner.
Yeah.
That food, the difference between the bull and the cow, apart from being male, female, as is common to all species, it's much more muscular, little taller,
Right.
and the content of the body, I mean, it's such that it can withstand fight, like all males in respect to female, normally.
This is not a bullfight between two bulls over a mating preference.
It's not. What you're saying is something different. What
Right.
you're saying is, if for thousands of years, they have this custom, tradition, but not about custom. I don't be thinking I'm
Tradition.
that they have been preparing that it's not as if domesticated, being a domesticated animal, they are not fit for performing. They are in fact trained for performing. Centuries, they have trained, this is a tradition which has been handed down to them. So they are actually, they are honed, they are especially sort of adapted. Not the, ordinarily domesticated bull everywhere. Like you have, material which show.
I don't think that's the case, but I'll just check up.
They have that key.
No,
They are being rare, they treat them with the greatest affection otherwise. That's their cases. It is not as if they are antagonistic to the bull. They rear them, they treat them like a member of the family. And finally, when this just part, you see, for example, there are two ways of looking at it. Man always has an interaction with animals.
Yeah, it does.
Man has an
Correct.
interaction. It is at various levels. You can be playful with your animal. The animal may even be hurt in the course of that playful encounter. Nobody will say it's cruelty. I don't think you will say it's cruelty. You have a dog, you play with it, you make it run, you do like all kinds of things. Nobody calls it cruelty. Only when it touches a particular level, like, we put artificial things, chili into the eye, things like that.
There
There are obviously nobody will permit that to happen.
No,
That is
obviously.
what was happening earlier.
Obviously, where does your lordship arrive at that? Obviously, it has been happening and it continues to
No,
happen.
obviously we are saying it was happening and it was wrong. We are not for a moment saying that the court, that is where the courts came in, stepped in and said that is wrong. But
Right.
that is
Correct,
not
correct.
going to happen at all in the future.
But it's
Unless we
happening.
say-
I have given you all those reports which are not
What
contradicted.
my London brother here said, we have to look at what the rule provides for. We'll have to see that it is ensured, that it is guaranteed, that if the rules are complied with. We can't be proceeding on the basis that the rules will be violated and therefore the rule is bad.
No, okay, so let me respond to that. So first of all, the rule is being violated and it's being violated wholesale because I've given you uncontradicted material, which is, I've read it only from 1 year, but that 1 year report of 2022 also summarized what was found in the previous years in the text portion of it. So it's an extraordinarily cruelty. So now, that's just, I'm going to respond to this point itself.
Must point that they are specially trained. This species are, in Tamil Nadu, they have this tradition and the bulls are being trained. That is
That
not
is
that.
what they have said, that there is a certain type of bull. If your lordship just sees the
that-
act, your lordship will just see the statute itself. Just see the amending statute
That's right.
and the SOR.
One more thing.
Oh, volume. Yes, yes.
Besides Perumpurium, is it any case of a subsilentium? That is also one of the grounds, which can be gone into by taken into account by the higher court.
Sub-silent. Sorry, but I didn't follow the question.
You said that normally when a decision is there,
Yeah.
the bench of course the more strength.
Right.
Of course, whether they can look into that question.
Yeah.
You said that of course Perumpurium that can be gone into.
Yes.
But at the same time, a case of a subsilentium can also.
So let me answer this issue on sub-silent. I'll just formulate my answer.
There is also instances where these can. On that possibility. Besides Perumpurium, subsilentium. What's
Yes. So now I'm just endeavoring to answer the question which was put. Let me at least supply my understanding of the law as far as revisiting a decision of this court is concerned. I believe it's absolutely clear on the strength of the decision that I said that there is no intra-court appeal insofar as this. I think that's absolutely clear because that's the Justice Sawant judgment. Please don't just make us an intra-court appeal because you're sitting in a larger combination, etc. So that's out. That's one. The second pillar is that, look, there is a recourse under the Constitution, which is Article 137. And of course, your lordships have created under the Rupa Hura case one more curative scheme if there's some great miscarriage of justice. But even that is a much narrower area than even available insofar as review jurisdiction is concerned. The third element which I want to flag is that because rule of law is so important and the credibility of this court as an institution is also dependent on finality of judgments, there are restricted categories. I'm not saying, I don't think there's any wisdom in defining all the categories available to the court. I think that will have to be kept open-ended. But illustrative of the sort of cases where a larger panel may revisit is a situation, and one is per incurium, which I have made my submission may not apply over here because the facts and the law have been looked at exhaustively. That's one element. The second question is, and which we pointed out, if there is some completely fundamental error. Now, one of the fundamental errors could have been that, look, where are animal rights? You have mentioned animal rights in your final operative direction is that please give a constitutional rights. What is this notion of animal rights, etc.? It's a fundamental error. The answer is no, that's not a fundamental error, because the court has very carefully used the expression animal rights in two contexts. One, not because we are saying X or Y or Z or that we are overturning Salmon on jurisprudence. No. There is an express duty which is cast as far as human beings is concerned, and the corresponding element the court has described as a right. That's about it, not as if there is some right by which an animal can go to court tomorrow and say that please enforce this right. And there are 5 universal freedoms which I have taken your lordship through, so that's the context in which animal rights as a compendious expression has been used to capture these broadly. So there's no fundamental flaw on that as well. Now, if that is not the case, the question I ask myself is, what is the great error in terms of some public cause? Because that may be also, there may be some, see, I think those L. Chandra Kumar, etc. cases which were given to me, which were cited and rightly so, were in case of the entire constitutional machinery in terms of redress. So that is one. Then you have a large number of cases, your lordship recalls, even in the arbitration field, as far as section 11 is concerned, two judges, 3, 5, 7. It kept going up and there were alternate, and then there was a legislative intervention. So that also had to do with some fundamental issue insofar as commercial law is concerned, and the court found that it had to correct or fine-tune, etc. But there was something fundamental with having huge and enormous public impact. I don't believe those criteria are met over here at all. As far as sub silentio is concerned, my understanding of that doctrine is that you could have certain situations where there is an undercurrent which is running through a judgment which is not completely and fully articulated. Now, I don't believe there is some such articulation over here in Nagaraj which makes it vulnerable. That's my submission. The articulation insofar as Nagaraj is concerned is express. It is right there in the face for each one of us to read. It is very well reasoned and well considered. That's my point of view. And ultimately, whether right or wrong, it doesn't fulfill the criteria in our respectful submission, which would invite an overturning.
Sub silentio operates in the field of precedent.
But it's precedent.
It may not have any application here.
It may not, because yes, as a larger panel your lordships have held, you may be able to rob a smaller combination's judgment of its precedential value.
So it's
Yes.
for the purpose of here.
Yes.
Here we are
May not quite arise.
we are not dealing with precedent.
Yes.
Here we are dealing with the question whether the legislature can take away the right.
Yes.
That
Of course, on the larger point.
That is it.
Now, just have a look at the Act, since your lordship put this to me. The Act itself is at page 137 of volume 1.
Yes.
I'm not taking you through the analysis because Mr. Luthra has already done so, but I thought I'll just point out page 137 of volume 1 of the convenience compilation. An act to amend the Prevention of Cruelty to Animals Act 1960 so as to preserve.
1 second.
Sorry. Yes, I'm so sorry. Okay.
lighter note, Sham is telling, we are actually never asked the bulls whether they would like to have a run with the human beings. Give it back to them for what they have been doing it to, what they have been-
There was
an opportunity for them.
there's a famous article, which was a scholarly piece written by an American scholar in, I think, the Yale Law Journal in the 1970s on should trees have standing? Should trees have standing? And so then he explained it in as to why trees should be given standing, which was a question which your lordships also had come up. Let's give them standing so that they can, whatever, forest rights, etc. Then there was I can only describe it as rather cheeky and cute response which came in some Harvard Law Journal or something, where he says exactly what your lordship said. That look, I have a river which has been flowing for millions of years, but I want to be dammed. And then it talks about another mountain slope, I remember, which says, look, I want a ski lift for tens of thousands, millions of years I have had no ski lift, so please put a ski lift, please dam me, etc. But it was meant as a cheeky response. But your lordship is quite right. We cannot. Now, in this regard, there's a whole developing science now on sentient creatures, and I'll cite just one article on that. When you have creatures themselves, now the science is indicating that they are capable of feeling pain. They're feeling, they're not emotions, complex emotions as you and I would understand that expression. But then what is to be done? So I'll come to that separately. But now I'm answering the question put to me with regard to these traditional, the species of bull. Now just see what their act says, the amending act. An act to amend the Prevention of Cruelty to Animals Act so as to preserve the cultural heritage of the state of Tamil Nadu and to ensure the survival and well-being of native breeds of bulls. Now, I strongly commend to the state of Tamil Nadu, and we support anything and action being done for the well-being of the native breeds of bulls. By all means, as your lordship correctly said, they are worshipped. Of course, they should be worshipped. They are looked after and with the greatest love and care. Yes, please do that. But can you subject them to cruel treatment? As a justification, the answer is no. But now let's see what they have said first. So see the definition of Jallikattu in double D. Jallikattu means an event involving bulls conducted with a view to follow tradition and culture on such days for the months of January to May of a calendar year in such place and may be notified by the state government and include so-and-so, so-and-so, so-and-so. And then your lordships will see the carve-outs which are conducted in the conduct of, please see in 11.3e, the conduct of Jallikattu with a view to follow and promote tradition and culture and ensure the preservation of native breeds of bulls and also their safety, security and well-being. There is not a jot, there's not one line which says that because of that, unless we hold Jallikattu and subject it to all sorts of inhuman and cruel treatment, that this particular native species or breeds is going to be unwell or it is not going to be secure. So what our respectful submission is, there are a huge line of traditional bulls in India, except and obviously cattle, bovine creatures. Those lines, some of them are outstanding. I mean, in terms of, I'm talking bovine, male as well as female, for the purpose, say, as far as milk production is concerned. Others may be very strong animals for the purposes of pulling, etc., and draft animals. Yet others may be have utilities which are otherwise. And you may have utilities and you may want to preserve bulls, etc., and traditional bulls because of their size, because of their beauty, because of their horns, and all sorts of things. So we are not against that at all. Please do so. Please set aside funds. Please create goshalas or whatever you want and preserve these bulls. But that doesn't mean you subject them through a carve-out over here to cruel treatment. That object itself, this is the point, that object itself after a determination of this court is per se illegal according to me. Is preserving your tradition and culture illegal? No. Emphatically no. You may do so. Is preserving a breed of bulls bad or illegal? Answer is no. It is, of course, it is good and in the interest of the bulls and the species, we must encourage it. But is continuing an event which is defined over here as Jallikattu, which has been found by this court and which has been found by these reports as inflicting untold misery on the animals, those specific animals which are worshipped at other times of the years, that is clearly not permissible. It's an illegal object. So anyway, there is nothing here which your lordship will find in the statute itself, apart from these particular, and also in 27, the amendment, the conduct of Jallikattu with a view to follow and promote tradition and culture and ensure the survival and continuance of native breeds. This event is not dependent, the survival of native breeds is not dependent on Jallikattu at all, is my respectful submission. It's absolutely irrational, according to me, and it is manifestly arbitrary. Now, there is also a statement of objects and reasons to the Act, which I'll just place before you because there's one line in that as well. And I just indicate it refers to the Supreme Court judgment in Animal Welfare Board has found that the conduct of Jallikattu is violative of the provisions of the Central Act, particularly 3, 11 and 22. Considering the vital role played by the event of Jallikattu in preserving and promoting tradition and culture among the people in large parts of the state of Tamil Nadu, and also considering the vital role of Jallikattu in ensuring survival and continuance of native breeds of bull, the government of Tamil Nadu has decided to exempt the conduct of Jallikattu from the provisions of the Central Act 59 of 60. Therefore, the government has decided to amend, etc., etc. So I would respectfully submit that when you apply the traditional test under Article 14 of having some sort of a reasonable classification, for example, that is not met because here, frankly speaking, while the state might have an objective with regard to a particular type of bull, there's nothing on the ground to show that there is X or Y or Z. But those bulls must be preserved. I'm not saying that line must be preserved. But this is not a condition, precedent, or even a requirement for preserving that line of native breeds at all. There's no rational nexus at all, and certainly not if it is subjected to this kind of inhuman and cruel treatment. That's my respectful submission.
While you're on Article 14,
Yes.
you also raised the argument based on Article 14.
Yes.
This 21, almost you have given up. Actually, you are not pressing that line of argument. 19 is obviously not available because the bull is not a citizen.
But 21, I told your lordships,
we have already said that. I mean, we have taken note.
And you recall, I read that report about people dying.
People dying. That argument is there. Actually,
Yeah,
it's
so-
not the animal as such being a.
No, and then I gave that penumbra argument, but your lordship is saying is absolutely right. I am not saying the bull has an Article 21 right. If that's the question being put to me.
No, we are putting something in.
Yeah, but there's an element of dignity.
You brought in manifest arbitrariness.
Yes, that's 14. And
that's
dignity,
very-
because dignity is an important asset. Other council will develop it.
That's
Dignity under 21 is an important facet of 21.
That's right.
And maintain, once we have a judgment of this court, apart from the non-retrogression argument, allowing something which is so cruel and torturous to a bull and compelling it to fight and contest lowers the dignity of each one of us. That's the submission, but that's someone else will develop. So I'm not putting sort of 21 into a waste paper basket for the purpose of my case. But it's not something which I'm going to elaborate on because others will do it.
I think please read Article 14.
Yes, of course.
Just read Article 14.
Yes. Yes. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Correct.
The question we are putting to you.
Yeah.
For the purpose of Article 14,
Yeah.
it doesn't matter whether you are a citizen or you are not a citizen.
Yeah.
But you have to be a human being. The word person. We're just putting it to you so that you can just clear because the same argument which you very rightfully,
Right.
in a manner of speaking, gave up the context of Article 21, personhood.
Right.
Whether the same problem will arise
Right.
in the context of Article 14 using the word person.
Right.
Can you say that?
No, so it doesn't arise. It doesn't arise. So let me answer that. We are on the text. Let's answer that straight away. The protection under 14, couched as it has, prevents or proscribes the state from violating equality in whatever manner. Obviously, the impact eventually will be on a person. But now let me answer respond. Supposing you have an arbitrary classification which doesn't deal with persons at all, but it says there's an arbitrary classification in a schedule to a taxing statute. There's an arbitrary classification with regard. So it has nothing to do with a person as such. You may only have companies, etc., which are impacted by that taxing statute.
It will always relate to a person.
Yes.
It will not see that.
So everything will come back to a person.
Classification relating to inanimate things.
Yeah.
But it relates to the right of a natural or a legal person.
That's good.
We are just trying to put you that I don't
Right,
feel
right.
Otherwise, you can't be having something in the abstract. It will always, rights are always related. They are
Yes.
always relative. There is no absolute right in the first place to begin with.
Right,
If
where
you
they are
will lose your
qualified.
life,
Yeah, the subject
when
to.
your life is not absolute.
Correct.
So when you're talking about right in the Article 14,
It must come back to a person, Malorjena. I'm not saying for a moment that it doesn't come back to a person. So, sorry.
So there, how will you actually deal with it?
No, so I will deal with it in this manner. I will deal with it in the manner that as far as 14 is concerned, I'll just explain, at least as I understand it, the evolution of the law. Initially, your lordships interpreted 14 as a basis of falling foul of a classification test. And this was a manner. Of course, fundamental rights are, in a sense, linked to individuals. They may be citizens, they may not be individual citizens, and as your lordship says, it may be a corporate person as well. No problem, difficulty with that. So, in the first realm, the construction and the manner in which this court interpreted it was on the basis of the classification test. Then your lordship supplied a further dimension to the issue, which was with regard to arbitrariness. So, arbitrariness also became a factor and even beyond the classification test. If some action was found to be arbitrary, then again it was liable to be or potentially liable to be struck down. Now that doctrine has further evolved and has further dimensions. Manifest arbitrariness is yet another factor or an aspect of it. And 14 has now been read with along with 21, 19, etc. and draws sustenance from all of them. So my respectful submission is the manner in which 14 appears. Yes.
There is one more issue there
Yes.
when we flag it.
Yes.
You see, how the law is developed from a mere classification. Of course, we had Anwar Ali.
Yes.
Right from Justice Vivian Bose, made that.
Yes.
But apart from that, the milestone is, of course, manifest, where you have a different approach to Article 14.
Yes.
So all of this is founded on a triangle approach. The triangle is 14, 19, and 21.
I believe that's correct.
Correct. Now, because the unenumerated rights in Article 21, rights which are proclaimed specifically in 19, you can find them, discover them, which has been done very effectively by this court in 21.
Right.
For all of that, you need the indispensable, the sheet anchor is, you need to have the premise 19 as well. Now, 19 obviously will not be available to an animal because he's not a natural person under the Citizenship Act. Only a natural person, as you know, the line of decision which says that a corporate body cannot, for example, maintain a 32 by itself. It has natural shareholders. So, unless and until you have 19 also being available, which is impossible in the case of animals because they can never be citizens of India. How do you bring in the theory of arbitrariness for animals? They're just dumb.
Yeah, so I'll just explain that to you.
You want this?
No, so let me just explain that to the court. Okay. So there has been, your lordships are correct in, identifying various markers in the development of our constitutional law. Now, there are two elements over here to it, which have worked simultaneously, particularly since the mid-80s.
Yeah.
One element has been the lowering of standing. And along with the lowering of standing or the lowering of the threshold for standing, locus standi, you had equally an expansion of rights under our Part 3 to extend and to cover rights which were, in a manner of speaking, not articulated expressly in the Constitution, but were found embedded because the value was there. And therefore, as the Constitution has been interpreted as an organic document, etc., moving forward, those have been ready. So now take the example I gave yesterday was the simple example of the right to a healthful environment or a wholesome environment. So that's not mentioned anywhere in our constitution, but it was derived right from the 1980s when you had, for example, the Dehradun quarrying case and a 32 petition was entertained, even though it was only in the early 1990s that for the first time it was said that the right to a healthful environment is actually embedded in the Constitution and in Article 21, and therefore we will engage 32. Now, what is the consequence of these two? What you have is situations. Now, for example, I'll just indicate, take something like the Wildlife Protection Act. That was also mentioned by Mr. Luthra. Now, in the Wildlife Protection Act, broadly, you have protected areas in its latest iteration. So you have, broadly, national parks and you have sanctuaries. And then you have other protected areas as well. Now, when you have a national park and a sanctuary, one way of looking at it is that look, if there's a national park and supposing the boundary of a national park is arbitrarily altered, I'm giving you an example. Who are you as a human being to challenge it, etc., under 14, 19 as being arbitrary? Because ultimately it's a question of the animals, etc., and they are not coming forward and they have no rights under 14, etc. But because we have lowered standing, because we have expanded the right under Article 21 and Article 14, it is available to a citizen to come forward and challenge an aspect, say, of the Wildlife Protection Act with regard to the alteration of a state boundary or of a national park boundary. Equally, now I'm coming to another example. You have schedules to the Wildlife Act. So certain schedules, that is also referred to by Mr. Rupta. So certain animals which are in a schedule enjoy the highest degree of protection no matter where the animal is. So even if whether the animal is in a sanctuary or outside the sanctuary, take a tiger for example, you can't kill a tiger except in terms of, so it could be well outside a protected area. Then there are species, all species are protected within a protected area. Certain species are protected whether within or outside the protected area. That's the broad scheme of the act. Then you have protections for plants, etc. also under that particular act. Now, if there is a violation or a movement, say, of a species which has enjoyed a higher degree of protection to a lower degree of protection, then the question is, what is to be done? So, is there any violation which has taken place? The answer is that through the human agency, this court has allowed. Now, for example, at 3 p.m. today, there's a special bench which is being constituted in Court 1. What is the thrust of that case? There is a bird called the Great Indian Bustard. It is on the brink of extinction. Now, the challenge in that particular petition under 21 is it's not that the bustard has come to the court over there and said that, look, my fundamental rights under 14 and 21. But there is a violation of rights because the state action has been found, or there's already an order of April 2021 of this court, finding that certain directions and rights have been infringed. The directions, certain action, I shouldn't say certain action has been found to fail the rationality and reasonable test for a particular species. So the answer is not that that species fundamental right under 14 is violated. The answer is in the context of that species, action which is being taken is arbitrary. And that allows an individual under the lower threshold under Article 14 to approach the court. Of course, a person may be right, a person may be wrong. But the threshold point which your lordship is correctly putting to me, that look, if it is not, if 14 is meant only for a person and 21 is only meant for a individual human being, then what happens insofar as bulls are concerned? So through a human agency, whether it is an animal protection agency or whether it's a statutory board like an animal welfare board or whatever, so what's our case just go back to the Nagaraj case. That's key before we had this act. What were the broad thrust of the case at that time, the earlier round? The broad thrust of the case was that, look, you have, apart from, I'm keeping aside this business about legislative competence, keep that aside for a moment. The point was that, look, you have a statutory board called the Animal Welfare Board, etc. This and the state, which is under a constitutional duty to protect bulls, is failing to do so. And the court, alive to this consideration and constitutional duty and responsibility, enforced it through its judgment. Now the judgment is available to us. So this is broadly how I would respond to 14. And I would respectfully submit that I don't think, I mean, of course, there's no second guessing what the state of Tamil Nadu will argue or any of the other states. But my sense is that the law has developed now by which an individual or a group or a registered society acting bona fide can approach this court and point to certain actions which are arbitrary, etc. So arbitrariness comes in another manner as well. It is a facet. It's a, when you have, if we are right, or even if if we may not eventually be right, but if there is some case for consideration, let me put it no higher than that, where a state seeks to overrule a Supreme Court judgment and breach the doctrine of separation of powers, which is fundamental to our constitutional scheme, I believe a group can bona fide come before the court. Your lordship will put each group to the test and say that, look, are you really bona fide or not? That's a separate answer and a threshold.
Yes.
I understand, I didn't know this, but I understand that Mr. Nagaraj had lost his son in that earlier round. He had lost his son in Jallikattu and therefore was seeking relief, etc. And including direction. That's the genesis of that earlier matter.
Awesome.
So, yeah, so there are dimensions. So that is, of course, a direct impact situation for the foundation of the case. But this is broadly where we stand on our understanding. Now, since we are on 14, let me just tie up this submission by referring to one 7-judge bench judgment. I'll just give you the citation and I'll give you the paragraph. It is Nagpur Improvement Trust versus Vitthal Rao, 73-1 SEC, page 500, and the relevant paragraph is para 26 at page 506. Now, let me just, while the book is being located, there's just one paragraph I want to read. While the book is being...
Most quoted judgment, actually.
Oh, I see, 73-1.
Number again.
Your Lordship will recall the facts. The facts were there were two methods of acquisition of land. One under the Improvement Trust Act, one under some general acquisition law, etc. But it was resulting in different sets of and different amounts being available to the party. In that context, 14 was examined and looked at very carefully. Is the book there?
Prior to this,
so,
Manil Gandhi.
Yes, 73. Yes, it is prior. It is prior. So, beloveds, I'll just indicate what the paragraph said, and
Basically, it's a part of the classification test.
Yes. So, but it's got one dimension. First of all, Your Lordship is absolutely right, correct in your recollection. It's pat on. It articulates the test. Now, the element which I am relying upon is not just that the classification should be clear and precise. That's one element. Second element is that it must have a rational nexus to the object being received, to be received. But there is one threshold requirement even prior to this. Even if your classification is clear, even if it has a rational nexus to the object sought to be achieved, there's one element which is at times forgotten, which this 7-judge bench articulates and is followed in a subsequent Supreme Court judgment, several, as Your Lordship said, but a constitution bench in Subramaniam Swamy as well. And that is that the object itself must be lawful and this is very, very important for my purposes. So the question being put to me is, or was put to me a little while earlier was, that look, you want to protect species of local bulls, etc. Is that an unlawful object? Certainly not. It's the most lawful object. But the issue is the means and the ends. You want to protect your a certain indigenous species, etc. By all means do so. But the manner of doing so, the object in that sense may be good. But to allow Jallikattu to do so is impermissible in law. That's an impermissible object. It's not a lawful object according to us. Yes, I'm sorry.
See, that observation was made in the context of the twin test.
Yeah.
In the context of the classification theory.
Absolutely right. It is purely that.
That object should be lawful thing.
Yes.
Itself is a part of the classification theory.
Well, first of all, I agree with that. Absolutely. So the argument therefore is...
So here there is no problem about classification. We are not on classification at all.
No, we are on classification.
No. Here nobody has raised the argument of classification.
Of course there is. It's a square on.
Please tell us.
How classification. Yeah, all right. So I just articulated in the most basic sense.
Yeah.
Bulls form a single homogeneous class. As far as bulls are concerned, as a classification. Now, if you are creating a certain subclass to subject certain types of bulls alone to cruel, unusual, torturous treatment, that is impermissible in law. So that's the traditional classification test, one element of it.
We'll never argue, that's why we're telling.
Oh, I see. I thought Mr. Luthra said, he said it. But anyway, now it's just a one single sentence point. So that's the point. So that's the first traditional point. Now I come to the second element. So I am trying to argue this on on the traditional test under 14 and on the more expanded test. So now I'm completing the second sentence is also on the traditional test. So therefore, my point is that you ought to, I can't say must, but the legislature ought to be alive to the interests of all the bulls of that species You cannot create an artificial distinction over here and certain bulls who are subject to torture, etc. If your object is to allow the entire species, etc., to flourish, by all means do so. So this is an impermissible classification of people or bulls which are put in the ring and which are subjected to unusual treatment. So this is one part. Second,
where is your pleading in this regard? Have you
the
made any
14
pleading?
ground.
No, have you raised a pleading?
I hope it's there. I mean,
Yes,
pull out
we also hope it is there.
14 point, my lord. It's a
No. This point is interesting. So that we'd like whether you're serious about it.
I have certainly, I mean, I must confess I've not seen it in my pleading, but I've not seen my pleadings at all. I've seen the reference questions which your lordship put to the court.
That's right.
And that articulates 14
Correct.
as one of the questions which has come up before this larger panel.
14 in the context of manifest arbitrariness is different from classification. So there we are asking you whether there is any pleading which you are now seeking to sort of argue.
I think there is at best it'll be some general pleading, but I'll try and locate it. Now, in any case, so the point here is 14 is very much there. 14 has various dimensions. Once the other side is on notice that there is a 14 issue, it has to be prepared and ready to answer all dimensions of 14. 14 is an evolving issue and 14 is in the reference order. So anyway, I will try and locate it from the pleadings, but I'll just tell your lordships. So this is one element. Now there's a second element to 14 in terms of the classic. So one is, so all bulls form a single, I mentioned that element. Now we come to the second. The object itself must be something, in the context of classification, Lord, in the object, what paragraph 26 says is that in this connection, it must be borne in mind that the object itself should be lawful. The object itself cannot be discriminatory. For otherwise, for instance, if the object is to discriminate against one section of the minority, discrimination cannot be justified on the ground that there is a reasonable classification. It's the same thing. So now, so that I have made that point. The object is bad. Why? Because you cannot subject certain elements, certain animals to cruelty. I mean, because we have a judgment in our favor on that, and I don't believe that can be really overturned. So that's the second element of it. The third element why the object is bad, again, traditional classification test, is because it is completely in breach of the doctrine of separation of powers. So yes, you may strike it down as colorable under separation of powers, but dimensions of 14 also kick in over here. Why? Because your whole purpose, your statement of objects and reasons mentions a judgment of the Supreme Court. And thereafter you say that I want to decide on the facts in the case. I want to decide on culture, etc., which is already decided by the Supreme Court. How is that permissible is the question I ask myself. So anyway, that is in itself, in our respectful submission, in the most traditional form, a violation of 14. So now, my lords, I'm done with 14.
The legislature not say that this is culture.
Yes, so now let me answer that. Let me answer that straight away. And I am in this regard fortified by the judgment of the Constitution Bench judgment of this court. So just allow me to go back to one paragraph in the judgment of Kerala versus Tamil Nadu, which I had cited yesterday. But let me answer the question. The answer to the question as we understand it is...
No, we remember that paragraph.
Yes.
Where you said that the purpose of a legislation cannot be to take away a vested.
No, not that. So first of all, let me try and furnish an explanation if we are right. I'm only answering the question. The legislature, which is plenary, may in many situations, virtually all situations or almost all situations, have, say, a deeming fiction. All right. So let's start with that. So can make a man, a woman. I don't know whether gender analogy is really very relevant at this time. But
tomorrow says morning is to be called.
Yes. So you can have a legislature which says morning is evening, sun rises on this side, etc. No problem with that. You can have a deeming fiction. That's the general traditional notion of the plenary power of a legislature, so long as it has subject matter competence. But then, with the progression, we have situations where the court decides. This is the most crucial factor. Once the court decides, this court or any other court, but certainly as far as this court is concerned, and it decides on an element of fact, not just based on fact, but it decides something on facts, and it decides an aspect of the law, namely, in this case, to answer the question as to whether there was a cultural root to a particular, and rejects it. then the legislature cannot overturn the judgment of this court through a legislative process because that violates separation of powers. So to answer the question, could they have done this before? Could they have done it? They did it through the 2009 Act. And I concede that instead of doing it through the 2009 Act, they could have amended the prevention of. For my purposes, I've conceded that because I've said it falls under 17 of the concurrent list. For my arguments, someone else may have another submission. So I'm conceding that position that they could have done this in the first instance. Point I'm making is they cannot do it after the Supreme Court judgment because that's what violates separation of powers, and that is why this court held that after this court in Kerala versus Tamil Nadu has said that look, 142 feet is the dam is safe up to 142 feet. The Kerala legislature cannot, on an appraisal of facts, come and say that look, I am deeming it that it is safe only up to 132 feet. And after that, the board is to decide. You can't undo a judgment of the court. That's the point. Once there's a factual determination, the whole arena shifts and moves into another space. And the matrix for evaluating the correctness of a judgment would be different before or after, even though you may have had a deeming power before that. So, my lords, now I'm done with this particular thing. Your lordship has already read that portion which says, cruel, barbaric, and inhuman and savage. Now, once a judgment of this court holds that certain conduct of Jallikattu is cruel, barbaric, inhuman, and savage, I would respectfully submit that any object to advance that kind of a practice is per se illegal once this court has so held. So anyway, I'm done with that submission. Now, my lords, there's one article on the sentient, and then I'm just going to go to those other 2-3 points which remain. So on the element as far as sentient creatures is concerned, there's just one article that I want to read, and that is just to explain, because this is a recent article in 2018 or 19. Have it given it? Please give it. So I should just mention, there are three pieces, three scholarly works which are already there in the convenience compilation. I am referring to the most recent one, which is in this new volume which I'm handing over, and I'm going to read only 2 or 3 paragraphs of this. So just so that you have an, just very quickly, just 2 paragraphs from this. So please go to page 8.
Yeah.
Now this is a piece by Suresh Kumar Sanjay Chaudhary et al. And it has been published, your lordships may just note, in the Animal Sentient, the title your lordship knows, it's in the International Journal of Current Microbiology and Applied Sciences, published in August 2019. You'll find that number and the reference right at the very top. Now, what is this new understanding? Let me just see. See the first paragraph. Sentience is the ability to perceive and feel things. An animal is sentient if it is capable of being aware of its surroundings, its relationship with other animals and humans, and of sensations in its own body, including pain, hunger, heat, or cold. In 2012, an international group of eminent neuroscientists signed the Cambridge Declaration on Consciousness, which confirmed that many animals, including all mammals and birds, possess the neurological substrates that generate consciousness. It is logical to suppose that sentient animals also enjoy feelings of comfort, enjoyment, contentment, and perhaps even great delight and joy. A sentient animal is a being who has interests, that is, a being who prefers desires or wants. These animals naturally try to avoid suffering and seek positive experiences. Just like humans, animals have evolved to cope as successfully as possible with life in the wild, thousands of years of domestication of farm animals, etc. So this is just to give you an introduction as to what is sentient and what is the direction in which the science is moving. And then your lordships may look at it if your lordship consider it appropriate. I think it's a very nice article. Brings us up to date. Please go directly to page 16, just in the conclusion. You will find in the right-hand column, sentience and cognition. The attribution of sentience to animals can also be hindered by the common misconception that capacity for sentience is linked in some way to the species' cognitive ability. Cognition refers to the mental action or process by which animals perceive, processes, and store information. Sentience, on the other hand, refers to the capacity of an animal to have feelings and to be aware of a variety of states and sensations, such as pleasure and suffering. It is often assumed that cognition and sentience are inextricably linked, in that cognition automatically implies sentience. Indeed, evidence of higher cognitive abilities, such as theory of mind and language, has previously been used as a basis for advocating for the rights of certain species, such as the great apes. Cognition is not actually a prerequisite for sentience, and it can be demonstrated independently. Developing our understanding of animal sentience is imperative for improving animal welfare and attitudes towards animals. Concentrating on filling the gaps in our knowledge humanely and reliably is essential given the extent of human impact on animals. With increasing attention on animal sentience, science and the further development of human approaches, the future of the science of animal sentience is looking even more promising, and as a result, so does the treatment of animals. So I am trying to only urge to the court that on part of that non-retrogression argument, that the science is actually moving in the direction and pointing in the direction which our court pointed us to in 2014. So this is the short point that I wanted to make with regard to sentience. Now, 2 or 3 points remain. One is in answer to your lordship's question yesterday with regard to those rules, and Justice Rastogi raised it this morning. So let me just hand over what has happened as we see protective measures and guidelines, and then come on here, take it. Give it to the other side. Now, very briefly, those reports which we gave, as I mentioned, and which we placed year upon year, have not been meaningfully contradicted.
Yeah.
Now, just let us see how this works. This table, your lordship has the tabulated statement.
This is the most important part, actually.
Very well. So, all right. So,
No, because this is what.
no, this is weighed with the court. So we put in, I mean, some effort. Let us hope it is adequate. Now, let me just summarize what broadly where we come out from. In one line, it's all old wine in a new bottle. That's one general comment which I want to make.
Yes.
The second comment I want to make is that look, while there may be a particularization under the 2017 Act rules, because the 2017 Act I placed in the morning, there's nothing really in that, it just carves out an exception. While there may be a further particularization, broadly what you will find is that the particularization, according to us, was already captured by some general catch-all phrase or responsibility or duty earlier. So please keep that in mind. That's number 2. And the third thing is that certain features which were present in 2009 are in fact diluted insofar as 2017. The other 3 broad points. So let's just see how this works. So now see the Tamil Nadu regulations, regulation of Jallikattu Act 2009. I'm on the first page. So regulation of Jallikattu. So the first is no permission under subsection 1 shall be granted to any person to conduct the event unless the collector satisfies himself that the event is conducted in January to May. The place selected is suitable for orderly conduct. The event should have been conducted during the past 5 years continuously. The event shall be held in a place notified by the collector in the district. Then we have set out, my lord, section 3.2 for your reference. Now look at the responsibility which was imposed on the organizer. Every person who organizes the event shall take all precautionary steps for the orderly conduct. Inform in writing if the collector, to the collector 30 days prior to the date of the event and obtain his permission. Double barricade the arena way through which the bulls pass, though in order to avoid injuries to spectators. Fix up the gallery for the spectators to sit and watch the event. 5. Arrange to obtain prior permission of the collector to persons who wish to bring their bulls to participate in the event. 6. Ensure that the bulls are put through proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to that effect. 7. To arrange and enroll the names and other particulars of the bull tamers in the event, with the collector at least 15 days prior to the holding of the event, and the bull tamers shall also be put to a thorough checkup by a medical team. Ensure that every bull tamer wears an exclusive dress for the sake of identification. Deposit with the collector a sum to be determined by the collector, which shall not be less than rupees 2 lakhs, etc. And then we have mentioned over here, overleaf on page 4, this has been omitted under the asterisk portion. Those responsibilities, we have said, have been omitted in so far as 2017 is concerned. Now, just moving on, carry out the responsibilities that may be prescribed. Then the arrangements made to be made by the collector, a very important section 5 of the 2009 Act. Collector shall ensure, so organizers' responsibility, now collector responsibility, ensure double barricading, ensure that the number of spectators does not exceed the limit under the prescribed by the PWD, ensure safety certificate by PWD, ensure that the bulls are free of any diseases and not intoxicated or administered with any substance like nicotine, cocaine, etc. Arrange and provide adequate police protection at places where the event is held. Arrange to provide adequate medical facilities, including the ambulance at the places where the event is held. 7. Arrange the necessary drinking water supply as well as sanitation facilities in place where the event is to be held. 8. Authorize the officer not below a rank of deputy collector to look after each item of the event arrangement, like checking up of the bulls, checking up of the bull tamers, checking up of barricading, gallery arrangements, medical facilities, water supply, sanitary arrangement, and safety of the spectators. Arrange to give wide publicity to the provisions of the Prevention of Cruelty to Animals Act 1960 and the rules framed thereunder, and the risk involved in participating. Ensure the presence of animal welfare activists representing the Animal Welfare Board. This has been completely removed in 2017. Videograph the entire event and provide the same to the government or any other authority as required, and make such arrangements as may be prescribed. Now I'm pausing here for a moment. This is a reading of Section 3, Section 4 of the 2009 Act and Section 5. Now, I first make my comment and then I go on to the right-hand side. After this, had the court's approach been, which I don't believe may have been a correct approach, subject to, of course, what your lordship said. If the court had said, Nagaraj, that look, these are rules, these are sections, these are statutory provisions, everything is fine, everything is perfectly conceived, etc. There is really no occasion. If there is someone remiss, if there is some deviation, then the recourse is for the party to be prosecuted or penalized or take action, etc. Answer is no, that may not be the correct approach. The correct approach for the court was what it did. It examined reports and affidavits, detailed reports and affidavits, where each of these obligations, your lordships have seen it, I don't want to take you, as far as the safety and sanitary conditions are concerned, as far as the violence and the pain is concerned, as far as the alcohol and other elements are concerned. I'm talking about Nagaraj. I'm not talking about my report. I'm talking about the reports and the affidavits which came before this court, which are extracted in extenso. And the court found that despite these so-called safeguards, the whole thing is illusory. And therefore, given the cruelty being heaped on the animals and the injuries, etc., which are being suffered, and the cruel and inhuman treatment, it doesn't comport with our sense of dignity. It doesn't comport with the requirements of the Act, the Prevention of Cruelty to the Act, and the purpose of the Act. Now see what they have done in 2017. I'm going to read this all on the right-hand column, again serial number 1. I'll read them in full. The Act itself is just the carve-out. So now they have the rules. Set out the procedure for conduct of Jallikattu. Rule 3.1. Any individual or organization intending to conduct Jallikattu in a place so-and-so under Section 2DD shall inform the collector of the district. Same thing is there. Organizers shall also obtain prior permission from the collector. Same thing is there. The collector shall grant permission for any Jallikattu, cause an inspection of the venue. Exactly the same as was there earlier. 3.4. Provide for formation of a committee of Jallikattu, which includes revenue, animal husbandry, police, health department. Your lordship recalls the earlier provision was to the same effect. Namely, these people had to be involved. Rule 3.5 specifies that the organizers have to ensure that the bulls are tested properly by the animal husbandry department. There was a mirror provision earlier. Provides for the collector shall ensure that help of animal husbandry department.
Don't rush there.
Sorry?
3.5 is important because
Yeah.
it says, and no performance enhancing drugs,
Yes.
irritants,
Yes.
etc. are administered to be
Yes.
correct.
Yes.
Now this word irritant, etc.
Yes.
Because when you're challenging a law,
Yeah.
it's always open to the court to actually read it down, to make it constitutional, as you are aware.
No, so see the earlier provision.
Because earlier provision did not provide for etc. irritants, etc. So
Well,
what
I'll just read the earlier provision. The collector had to ensure that the bulls are free of any diseases, not intoxicated or administered with any substance like nicotine, cocaine, with the object of making them more aggressive or ferocious.
they were performance enhancing narcotic substance.
Yes.
I mean, that apart, what we were really concerned, and we're going to put it to Tamil Nadu also,
Yeah.
whether they have, prevented, like spiking, like poking it with.
Of course, that's prevented, Manoj.
That is whether that is there or not in the rules.
But they're definitely there. The Tamil Nadu government is not allowing any such treatment. That can't be done. But it is being done. The problem, just imagine, as your lordship sees, if in your time your lordship goes through the photographs, you will see it, that those prods and those things are being used, and the whips and the lacerations, etc. are there, and those are documented in the text.
Were CCTV cameras, was it there under the old?
Yes, it was. Videography was there. So, brothers, as technology evolves now, you will have a live streaming also. We are not on that. But earlier, videography was there. I read it. Please just see the earlier rule. Where, sorry, page?
Videography may not be the same.
Page 5.
Videography
No,
may
page
not be
6.
the same.
Page 6, 9.
Page 6.
Right.
CCTV camera
Prominent
monitor
model.
all activities.
Videograph the entire event.
Yeah, videograph. You're absolutely right. 11. I think it's 11.
CCTV
Aye.
camera, Shyam,
Yeah.
CCTV camera to be fixed to record and monitor all activities is different from videography. Because videography, if you are going to capture only the parts, which are really palatable to their site, you may not get the whole picture.
Well, I think
CCTV camera, as long as it is working, if you not allow it to work, is a different matter.
your lordships have experience of CCTV camera. Can I share something?
Yeah.
Yeah. The CCTV camera is, apart from being an obnoxious invasion of privacy, because you see it all over the city just now. Not just public streets. We now have a mandate in this city that you have CCTV cameras in schools. One thing which I thought we were left with was at least childhood, where you can, we now have CCTV cameras in classrooms, etc. But anyway, that's for another day. Now, the point I'm making is that the CCTV camera enables you to reconstruct in certain situations. The granular condition of the feed which you get may or may not, because a lot of it depends on the angle from which the CCTV camera and the event which takes place. So, since your lordships have allowed me to share a personal experience, I can tell your lordship that I know of a particular person, a close relation, who had CCTV cameras which were installed for security purposes. The persons who engaged in mischief just shifted the CCTV camera in another direction, etc., and did exactly what they pleased, and thereafter refitted the CCTV camera or whatever in the manner. So CCTV camera, while it may serve a certain purpose. I'm not saying it doesn't serve a purpose, but essentially the benefit is not going to be with respect to those particular bulls for whom we have come over here and to prevent cruelty. It may, in some instances, prevent some reconstruction of events and to say that, oh, I said this and you said that. But you are not going to be able to really, in my experience, enhance your law enforcement. So the purpose of now I'm coming to this. The purpose of the CCTV camera across the world, by and large, is, and your lordship actually said it, that the CCTV camera should work. CCTV cameras are stationed in many parts of the world only to ensure that the action which a person takes is somehow, is to prevent improper action. Actually, those cameras are there. There may not even be a camera inside. There may be no feed. But the idea is it's a tool of deterrence. Because there's a CCTV camera, and X or Y or Z may feel that, oh, I shouldn't do X or Y or Z. But in reconstruction of crimes, etc., it may be possible. It's, of course, at a cost. But what I am trying to suggest to the court is that by having some, some small little improvement here and some, embroidery over there.
The basic rule.
The basic rules were there in 2009. Despite the basic rules in 2009, you had widespread violations which have been now found to be established. And therefore, my urging is twofold. my first urging is, that perhaps, possibly, a wiser way, or maybe I'll withdraw that expression wiser, but a better way of examining this law, the present impugned law, is the effect of the law and not based on the theory. Why? Because we had a submission, we had elaborate rules earlier, statutory provisions in a section earlier, but those failed to pass muster. They did not result in any meaningful alteration in conduct of the event which would be beneficial. Am I suggesting that every Jallikattu event? No, I am going by the basis of the record. The Supreme Court, well, the 2014 Nagraj judgment, I just gave you from one or two of those particular districts. It would be wrong to take up your lordship's time and read each one of them. At so many of the districts, the court found brazen violation year after year. Now, if you have this kind of treatment with statutory provision, this was, Malaj, don't forget, this was sections in the Act. This was not even subordinate legislation at that time. Today, it is subordinate legislation. Not that its subordinate legislation should be flouted. I'm not suggesting that. But it was a higher order, the 2009 State Act, which was completely breached wholesale. So, to complete, at least for this first set of obligations on the collector and on the owner, pari material, you may not find it court by court, but essentially the person has dressed it up and put it in the form of rules where all those say, because I'll tell you why. The reason I'm making is, I don't think the intention of the state as such, it was obviously the 2009 Act, the idea of the state was, it was hopeful of having some regulatory exercise. I'm not suggesting that they were some, the state government. They were not acting, they were acting bona fide, but even when they were acting bona fide in 2009, the legislature, on the ground, it didn't yield anything at all, as this court has found. And putting this old wine in a new bottle and trying to market it ought not to pass muster. So this is the first point. Now let's go to the second set of, please go to page 6. Now look at section 4 earlier. Ensure that the bulls are put to proper testing by the authorities of the Animal Husbandry Department to ensure that the performance enhancement drugs are not administered to the bulls in any form and shall obtain a certificate to the effect in such form as may be prescribed. Ensure that the bulls are free of any disease, not intoxicated, etc. So this was for 6 and 5, 6 of the section. Your Lordship has page 6, serial number 2. Now the Your Lordships have page 6. So the left-hand side, left-hand column is 2009, correct? Now look at the rule 4 at page 6. Now look at rule 4 on page 6. Examination of bulls. The bulls shall be compulsorily subject to veterinary examination by qualified veterinarians of the Animal Husbandry Department. Now, obviously, Manoj, when the earlier act also envisaged, the word veterinarian may not be used, but obviously the Animal Husbandry Department personnel would be all vets. Otherwise, where's the question? Who? A general lay person in the secretarial staff has no competence to say whether there is nicotine, cocaine.
Quantitative difference from the earlier section 4 with what you have put on the right-hand side.
Right.
The earlier thing was, see that are not administered any performance enhancement drugs, not administered, number 1. To ensure free from any disease. And
But these are not a quotation. You should just know. I've asked them to paraphrase it. Just telling you, it's not a quotation.
That's right.
It's a paraphrase.
But if you contrast it with what you find on the right-hand side, they include both showing symptoms of fatigue, dehydration, restlessness.
Correct.
Shall be identified and not permitted. These bulls shall be examined specifically for possible alcohol and for subject to any such abuse shall not be allowed to participate.
Right.
So it is more elaborate.
I agree with you. I am for a moment.
More elaborate and goes to detail.
So may I just answer that? May I just respond to that? First and foremost, it is not necessarily more elaborate in the sense that it was not covered earlier. So I'll just explain that. You might have had a particularization in the 2017 rules, which was not particularized in the 2009 Act, but it was covered by the 2009. Well, let's be.
The matter goes to substance.
No, I'll just explain.
Particularization itself is such that it knocks out the basis of the cruelty according to it. that, for example, if you see
No,
a particular bull,
Yeah.
see, there are bulls and bulls.
Ah,
They
yes,
may be
yes.
trained, they may be fed.
Right.
Correct. But at the time when the actual fight takes place or the Jallikattu takes place,
Yeah.
then the officer whom we have to pursue by statute ordains that he should perform a particular act.
Yeah.
So that he performs his act. Let us assume that the act actually goes on well. That's one way of testing the constitutional
But
law.
I agree, but that is, if I were
That
arguing in
is so.
2013.
The bull showing dehydration, restlessness, identified, not
Right.
permitted to participate.
Right.
So this was not there earlier. They were not.
No, it was very much there earlier.
No.
And I'll show you the corresponding provision.
Not there.
No, I'll just show you that. Just give you the equivalent to that. We'll give you the equivalent provision as well. So, Manoj, I want to just respond to that situation. You had rules in the form, rules in the sense, I'm using the expression in the form of detailed statutory provisions in the section under the 2009 Act, which corresponded to this. You're quite right. The word vet may not be used, the word animal husbandry department may be used. But specifying a vet doesn't mean who else in the animal husbandry department would know X or Y or Z. There may be some further, with the advance of science, for example, you may have a substitute of videography with a CCTV camera because CCTV cameras may be cheaper, etc. But that in itself is not a qualitative difference from the perspective of the bull.
Rule 5 you come to. That is very important. Rule 5 over the page, yeah.
Just give me a moment, please. Sorry.
Rule 5, if you in the meantime, if you may read.
Yeah, Millers of the new rules?
Yes.
Yes.
Over the page, next page, page 7.
Yes, so may I just read that?
There is no equivalent in the earlier.
Yeah, that is so. Arenas shall be at least 50 square meters area. The bulls have to be embraced by the participants within 50 square meter area. The participants shall not be permitted to stand in front of the bulls as they enter. They shall also not be permitted to block the exit way for the bulls. The participants shall be permitted, etc., some 15 meters or up to 30 seconds or sustain 3 jumps of the bull. The participants shall not hold on to the tail, horns, using their hands or restrict the movement of the bulls by holding on to the bull's legs. The participants violating these guidelines shall be liable to be debarred.
Just pause there for a moment.
Right.
It's a matter of some moment because
Right.
you're talking about the flight response, the fear.
Right.
A large part of this fear can be attributed to the acts of the human being, holding on to the tail. Now, this is that part. We thought that there might be of some importance.
So I'll just tell you. Let me just tell
Talking
you.
out the basis of.
So let me just the foundation of the previous judgment. Let me just explain that to you without reading any paragraphs. The idea, I'll just explain it to you in very general sense. So you have a bull. The bull is a domesticated animal. It is being, revered for the rest of the year, etc. And it does what a bull does. Now at this stage, now it's a calm animal. We don't know what's passing through its mind, but it's sentient. That's what the science seems to suggest. It has a certain abilities over there in terms of pain, etc. Now, when it is put in an artificial setting, this is now the performance ring, correct? You remember that the performance was banned for all the circuses. That's why today our circuses don't have it, including insofar as bulls are concerned. Now we are coming to that, whether it's a bullock cart race or this. I am concerned, of course, with Tamil Nadu. Now, what's happening in this context is that suddenly the bull, from doing what it generally does, which is whatever, munching, eating, browsing, etc., it is put into an arena. Now, putting it in an arena itself may cause or trigger a certain panic by which it wants to leave the arena, but it is not able to do so. It wants to flee. The flight or fight response is that generally the bull will fly. It will try and leave, but it is completely barricaded and prevented. That itself is cruel. That itself is cruel insofar as an arena with spectators shouting, hooting, whatever, etc. So there's a panic response. Now I'll just complete, sorry.
Just when you say that.
Yes.
The second sentence of Rule 5.2.
Yeah.
They shall also not be permitted to block the exit way of the bull.
Yes. Yes.
Earlier, what would happen perhaps is
Yeah.
they would surround it.
Yes, there is.
Create that flight response. So the human beings derive, joy out of it. That is an animal right in front of us.
Of course.
That was the whole idea.
No, but
Now,
you,
they have now made a change. The radical as it appears to be that they shall not stand in the way. They shall not stand in the beginning, that is the entry point. They shall not block the exit. So they have made it a little bit, at least.
no, it's like participants, my lords.
I'm talking about the participants.
But who is to tell the bull? The bull, I'm just asking your lordships. The cruelty is because you have a large arena. I'm assuming there's a large arena. You saw some of the reports said there was no arena and it was being conducted in the village center, etc. Keep that aside. Assuming you have a large arena, it's not as if the bull can read an exit sign or something like that and say that this is the way out and I will follow that and someone is blocked. There is a huge, my lord, spectacle going on over there. We have shown you. Now you may have to go to the photographs and see how it's actually conducted. This is not a parade or something which you see while beating the retreat with the horses in a leisurely manner coming. This is a spectacle. This is an event. And it's an event intrinsically. Maybe you may want to condone it. That's another matter. But intrinsically cruel as far as it has been played out in the recent past. Because I don't know. We don't know what the tradition. But at least from 2014, 2009 to 2014, we have a final judgment of this court. 2017 onwards, we have a whole bunch of reports of this court. It is still played out in a cruel and what we term as an inhuman manner. Because of, as your lordship said, there's some sort of a contest. There is some, people are trying to show their whatever notion of strength, etc. Because the bull itself is a notion of strength. But we believe that this is really, from any reasonable perspective, having a gate, which, I mean, I don't think anyone is suggesting that the bull knows exactly where the exit is, etc. It's not really, it's cosmetic. Let me put it this way. These changes are, in my respectful submission, cosmetic, given the overall, and given our experience. Why am I going into that? My submission is anchored on facts and on the basis of PETA reports. Anchored on the basis of those PETA reports, this is something which does not happen and the cruelty subsists. Now look at the next thing, point 4, the bull run area. Look at that. So earlier it was double barricade the arena or the way through which the bulls pass through in order to avoid injuries to the spectators. Sorry.
So they'll have to do the explaining. You can perhaps, reserve your, if you wish to file a reply. I mean, make a
Yeah, correct. So your lordships have gone through the rest.
Yes, we have seen.
All right, I'm very grateful. Thank you. So now, my lords, and we have mentioned some parts which are not there. Rest of the table. Fair enough? Okay. So essentially, I mean, in a line, this is a cosmetic change. Right? That's my idea. So
we
just give me a moment.
have given you sufficient time.
Yes, absolutely.
More than.
The reported judgment.
In this case,
Yes,
as we will
So
demonstrate.
I'll just mention.
So, can we move on?
Yes.
Yeah.
Well, I'm done. There's just sorry.
Cannot hold on.
Look, I am done now. I'll just take 2 minutes. I want to answer those questions which were also put to me. And see, just let's look. I'm just stepping back from what has happened. The broad submission that I want to make in terms of the legislature's ability, and I'm going back to the point regarding colorable. Once this court has found that this is inherently cruel, can the state legislature, through an amendment to the Central Act, modify the mandate under the Central Act?
These are suspended submission.
in my respectful submission, I'm just looking at it differently. If the state legislature could do that, what's the effect is the question I ask you. What's the effect? The effect is that a final judgment of this court, which can be only overturned by this court, without removing the substratum in terms of the factual determinations, etc., gets ultimately overturned. And that I don't believe is a permissible exercise, and therefore it is deeply colorable. Now, finally, the answer, can they not make a fresh legislation with safeguards? I have two answers. The safeguards were already there and they were breached earlier. The safeguards introduced since 2017 continue to be breached, and therefore, in our respectful submission, there is absolutely no justification for sustaining this legislation. I'm very grateful. Thank you.
Thank you. Thank you. Who will give you argument?
It is removed. Yeah.
Tell us one thing. You argued from 2 o'clock to evening, 4 o'clock, yesterday,
Yes, I'm sorry. I thought I'll take half an hour.
without taking a drop of water even. Not water at all, and you're going on continuously. Without even.
This species is not a sentient creature.
With no cognitive ability. I'm very grateful.
After such a long time, that you just either have some sip of water.
I think I should have been briefer. But thank you very much. It was a very nice.
So, at least you enlighten us on a different subject. Totally in a different way.
Very grateful. Thank you.
Youth power.
Yes, Giri.
Wait, please, Your Lord.
Yes, you are appearing for.
I beg to appear in the list of cases, my Lord, where different counsel are appearing. There are two writ petitions, my Lord, where I appear
For the petitioner?
for the petition. I beg to appear in writ petition number 25 of 2016.
25 of
2016. And then writ petition number 1193 of 2017.
25 of 2016.
16. Yes.
The act came only in
It
2017.
was amended.
You have subsequently amended it.
Yes. Then, my Lord, there is anyway
1193 of
2017. That, my Lord, squarely challenges you.
70. Okay.
Yes.
So both are in Tamil Nadu. You are in Tamil Nadu.
Yes, yes. I'm only in that. I'm only in the Jallikattu.
So, see, the arguments have been fairly elaborately addressed by Divan.
My Lord, I will not.
tell you that, that just need not repeat
No, no.
whatever is there. You can adopt the.
If your Lordships feel that I'm repeating
No, no,
anything,
no, no.
Lordships may call.
That's
I'll immediately stop.
it. Correct. Need to go to Karnataka and also Maharashtra.
Lord, I am aware of it.
We just want to tell you that.
I'll not
if it's possible. So that,
Lord, it's only 15 minutes to lunch. I'll probably take half an hour to 45 minutes, not really.
Let us see, I mean, any new argument is there? Or?
Lordships may see whether there is anything.
Yes.
If there is nothing new, Lordships may cut me short.
we don't want to cut him short. We want to give him full word. Is it not possible that in return, after the reply comes forward, you get clarity?
Lords, let me do it now because a reply might be necessary once they do. They may have to reply to something which I argue now. They may have to. I believe they have to.
All right, go ahead.
Master.
Lord, just the basics of the contours of what I may not wish to submit with respect. The correctness of Nagaraj or the order passed, my Lord, in the review petition is really not one of the issues that come up for consideration.
Why files are not?
Correctness of the finding, sorry.
Files क्यों नहीं दे रहे?
Files दे दो.
WPC 25 of 2016 and WPC 1190 of 2017.
I think it has been. All right, then Lordships may kindly confine to 1193 of 2017. That is enough. I thought it was amended, the earlier one, but your lordship may confine to 1193 of 27. That contains a frontal challenge to this. The earlier it 2016, your lordships are right. Lordships may ignore that.
So 1193.
But I had also prepared on the basis
Not
of
this,
the
not this.
2017 petition.
Court master, not this.
If your lordships have. Only the 2017 need be.
1193. 1193.
1193 is enough. I'm sorry to have trouble.
Yeah.
My lord has to still get the files in.
No, we have not got.
After the. Right. Yeah.
My lords have got the files.
Whether Roy is got it.
I've got it.
Yes.
Yeah, tell us what you
Now,
have.
my lords, please note 3 or 4 dates, my lord, which might turn out to be,
Yeah.
my lord, relevant in developing my speech. Nagaraj, my lord, the judgment is delivered on 7/5/2014.
Okay.
7/5/14.
2014. Nagaraj, my lord, dealt with the competence and virus, my lord, of the 2009 Tamil Nadu state. Essentially. And it also went into the other issues which cropped up for consideration. Lordships have seen Nagaraj.
Yeah.
My lord, an application for review was filed by the state in Nagaraj,
Yeah.
which was dismissed on 16/11/2016.
Yeah.
My lord, an ordinance which has led to the act in question
Yeah.
was promulgated on 21/1/2017.
Yeah.
And the impugned act is passed on 31/1/2017, deemed to have come into force from 21/1/2017.
21/1/17. Yeah.
No, my lords, the order in review passed on 16/11/2016 is not a non-speaking order saying that we don't find any grounds to review. The order, my lords, the learned judges will not go into the contention, they appreciate the contentions. And then they reaffirm the findings, my lord, given in the main judgment in Nagaraj, but also come out with certain other findings, my lord, which your lordships have seen. Some of them, my lord, I beg to place before your lordships. Point is, my lord, your lordships have always appreciated the difference between adjudicated facts and legislative facts. Adjudicated facts are facts, my lord, which are placed before the court. And, my lords, this honorable court adjudicates on such facts. They have a relation, my lord, to the parties before the court. Parties are heard on them. Conclusions, my lord, are arrived at on facts, saying that it has been established on facts that such and such is the state of affairs. Those are adjudicated facts falling strictly within the relevance, my lord, of an adjudicatory body. And especially so, my lord, they are entitled to a sanctity when the adjudication is done by the highest forum in the land. My lords, the facts which must have persuaded, my lords, the legislature in the earlier instance in 2009 to come out with an act, my lord, are broader. They are legislative facts.
Yeah.
My lord, the challenge to the act in question was predicated on several, my lord, aspects,
Yeah.
including, my lord, repugnancy under Article 254. That, my lords, that this violates, therefore, the provisions or it is in conflict with the provisions contained in the Central Act.
Correct.
That this seems to be, the argument of the state seems to be that this practice of Jallikattu is rooted in the culture and heritage of the state, which is peculiar to the state.
Correct.
And therefore, the organization of Jallikattu by itself, the organizing of Jallikattu by itself, cannot be treated as a cruelty, or the participation of the bulls in the Jallikattu as an event And all such things which take place, my lord, in seeing that such an event is organized, will not amount to a cruelty
Correct.
within the meaning of the Prevention of Cruelty to Animals Act of 1960.
Yeah.
My lord, the nature of the animals, their essential characteristics, the fact that they are sentient animals, the fact, my lord, that they are unsuited to participate in an event of this nature, the fact that, my lords, that the actual organization of the event cannot keep at bay, my lord, acts which amount to a cruelty, subjecting the animals to unnecessary pain and suffering. My lord, I use the words because those are the words, my lord, which resound from the reading of the act. Is really has been adjudicated upon by the court, and the court says that no, this can't be done. But there is also, my lord, a finding of fact. These are adjudicated facts, my lord, by this honorable court, and it can't go higher than that. There is a reaffirmation of these adjudicated facts, my lord, in the review order. My lord, it's too late in the day, my lord, and I really cannot advance an argument before your lordship that the legislature is not empowered, my lord, to come forth with the law. If it removes the basis of the judgment, if it is otherwise legislatively competent, and, my lord, it does not violate any other constitutional provision, and more particularly, my lord, any provision contained, my lord, in Part 3. The legislature is entitled to step in. It can remove the basis of the judgment. And in doing so, my lord, it therefore exercises a power, my lord, within its competence, provided it is within the legislative competence of the state. My lord, when it is challenged before your lordships will look at it from several angles, because the challenge is on the ground that it is not competent. Why it is not competent? Because, my lord, it strictly doesn't fall within entry 17 of list 3. A legislation of this nature, by which, my lord, the state brings about an amendment to the Central Act, carving out an exception, as it were, my lord, to the scheme that has been outlined with the Central Act, may not really fall within the competence of the legislature under entry 17. Why? I'll take your lordships to that. Secondly, my lord, if the legislature, when the law is challenged on the ground, then the legislature has usurped the judicial power or has transgressed into a territory which was occupied by the court's judgment, my lord, which has been rendered after hearing both sides, and a detailed judgment at that. Is there any factual material that is placed before the court, my lord, to say that these are legislative facts that have been assimilated by the legislature post the judgment and post the review order, which had persuaded, my lord, the state originally to come out with an ordinance, promulgate the governor to come out with an ordinance, and thereafter, my lord, place it before the floor of the assembly, and then, sorry. Very, very good. we pleaded, my lord, in support of
I just take.
the legislation which was there earlier, including, my lord, on the preservation of the culture and heritage had been put forth, had been adjudicated upon, and thereafter, my lord, they come out with an ordinance within 45 days.
That's right.
Whereas the legislative facts which cannot be gone into by your lordships.
That's right.
But
Therefore,
therefore, my lord, the question is, where is the fact, where is the legislative facts which have been taken note of, my lord, for the government after all, my lord, prepares a bill and then.
That
places
also we
it.
don't think we can prove it.
Very well, my lord, I am not taking it to that. I am saying, my lord, that it may not come within the
Well, that's before my friend continues. Well, I just wanted to know what the lay of the land is. Well, after this, will Tamil Nadu have to respond, or are you going to hear Maharashtra and other?
We hear the round of the petitioners, and everything should be concluded by tomorrow. What we intend to do is, and we also intend to tell the court officer.
No. I'm talking about my response.
Should tell the registry not to put the alternate list tomorrow. Because this is going to go and it will be over by tomorrow. We hope that it will be over.
That's the other side, Manoj.
No, the whole of it. Otherwise, what will be, it will go on.
That's not possible.
The wholesome way of doing it is petitioner side is over, so the respondents.
I just wanted to know that,
What
Manoj.
we can do.
If that's what you're.
So you don't have to, if you were saying that you want to go somewhere.
No, it's not that, Manoj. What is, there's a partnered matter.
Today, because let them be over, that's the petitioner side.
Well, I can reply tomorrow morning if your lordships give me a chance. I can reply in the morning at 10:30, Manoj. If your lordships will allow me to do that.
Because in any case, the constitution bank not.
No, we should not go against. I mean, we have no problem, but the lawyers are put in difficulty.
Lawyer doesn't know when this pen will collapse, not collapse. He's having a list of 40 matters on board.
That's an outrage.
This can collapse.
This is not public.
I don't mind anything, Manoj. I just want a chance tomorrow morning at 10:30.
Petitioners argue, your lordship knows, Mr. Luthra and Mr. Diwan have argued one, and they've not argued on dignity at all.
So whatever it is.
So we can finish by tomorrow, there's no
It
difficulty.
should be over today.
No, there are at least another 5-6 councils.
Whoever it is, they'll have to conclude today. This we cannot go on like that.
Very difficult, my lord.
You will have to supplement it with written submission.
Lord, it's very difficult to do it because this is a sui generis,
That's right, that's right.
but matter which is sui generis.
We have heard, we have to also regulate the.
And of seminal importance, my lord. And the lordships have asked so many questions, they have to be answered.
Great respect, my lord. Judgment passed by this honorable court was stayed by the Madras High Court. Against which, my lord, Justice Panika Radhakrishnan himself has filed a petition which is pending before the three-judge bench. That also can be listed along with.
Whatever is listed before us, that is good enough for us. You argue, go on, otherwise we go on.
Lord, let me
Nagarajan,
go on
this
with.
matter goes to the root of Nagarajan itself.
You go and you argue.
All I was saying is I should be given a chance. Oh, God.
We'll consider hearing depending on. Giri, go on.
Let me go on, my lord. Let me
Please, you
complete.
go on. We are telling you, we are not going.
Persons are disciplined.
No, you go on, and you are also conscious of what we have said.
Yes. My lord, therefore, my lord, I thought,
Yes.
I realized, my lord, I did not convey what I wanted to convey correctly. It is not my submission that your lordships would be called upon to consider either the quantitatively or qualitatively the legislative facts which were there before the legislature, before they enacted this legislation. That is not my intention. No, my lords, that is not something which your lordships ever do. It is not done. The submission, my lord, is that every facet of, my lord, every facet of the aspect by which this legislation is sought to be sustained, either on the ground, my lord, of my lord, repugnancy or absence of repugnancy, as the case may be, or that it is for the purpose of upholding culture and heritage of the state as such. Every fact of it, my lord, is not a legislative fact, but it actually has transformed into an adjudicated fact. That is what I want, my lord, to submit. Had it remained in the realms of a legislative fact, my lord, it
That
would
is already argued by Diwan. Of course, you
Lord,
can
sir,
supplement it. You can say
I only supplement.
inherently it is cruel. We just articulate so that you can cut out.
No,
See
not
that
that.
it is the act itself is inherently
No,
cruel to
no.
animal.
That's not.
That it can never be done.
That's not
Whatever you may do, you cannot do it. So that is changed. That cannot be changed.
Just give me some time so that, my lord, I develop it and leave it. I'm not repeating whatever has been stated. Kindly bear with me for just 10-15 minutes. I'll just place this and then your lordships may consider whether it is to be developed in more detail. No, my lords, please come to what I'm respectfully submitting is this. Please come to Nagaraj. The one fact, my lord, which will be put forth in my respectful submission is that this legislation seeks, my lord, to uphold the culture and heritage, my lord, of the state. Now, this was one aspect, my lord, which was pleaded as an argument on behalf of the state before Nagaraj, or at any rate, it was considered and there is an adjudication on that aspect. I will not read it again before your lordships due to lack of time, but please take paragraphs 53 to 56 down.
53 and 54, that was all.
Therefore, I am not reading it. Therefore, 53 to 56. Now, the preamble to the Act and the statement of objects and reasons says that it is to uphold the culture and heritage of the state, and that is why certain bulls are bred. And this is why the Jallikattu is also being held.
After Nagaraj, it is not available to them to say that.
That's what I wanted to submit. Because it's an adjudicated fact. It is not something, my lord, which will still remain in the realms of a legislative fact insofar as the legislature is concerned. There is a striking similarity between the statement of objects and reasons of the 2009 Act, which was looked into by Nagaraj, and the present enactment. But for the fact that this is now projected as an amendment to the PC Act, which is probably one way of saying that there is no repugnancy between this Act and the Central Act as such.
Therefore, what we thought was,
Yes,
you see, ultimate question perhaps might be
yes,
whether Jallikattu in any form
yes.
can be performed, allowed, or Jallikattu in any form cannot be done.
Lord,
Jallikattu, in other words, with safeguards which take care of the welfare of the animal involved, takes care of the human beings involved, whether the legislature in its wisdom, which normally we are subservient to, even in our judicial function, we do not say, no, we've got better wisdom.
No, you're not.
That is going to be the question.
Yes. No, my lord, let me respond to this. Jallikattu in a form that is modulated, that is regulated, or that is not possibly to be monitored in the manner as projected by the state, is it permissible? Or Jallikattu in all forms, whatever it is, or Jallikattu in all forms, whatever it is, as it should be banned, my lord, as Nagaraj has said. My lord, it's not a question which is it's not capable of, my lord, of one statement answer as such. But let me put it this way. The manner in which Jallikattu was sought to be regulated, or it could be, may not permitted, was put forth, my lord, in Nagaraj. My lord, why I keep coming back to that is because the Jallikattu by itself, my lord, has been the manner in which Jallikattu is to be conducted and why it is conducted. These were all matters, my lord, which were placed for adjudication before the Honorable Court. It is not anybody's case, let alone the state. And that is to be reflected, my lord, from a reading of the legislation. The Jallikattu in this form is permissible. Jallikattu in this form was never the subject matter of adjudication by the Honorable Court early. Jallikattu per se, my lord, according to them, amend section 3, amend section 11.3, amend section 22, amend section 28. Jallikattu is therefore taken out of the purview of the PCI.
Along with the change in the rules.
My lord, rules are subordinate rules. My lord, the validity of the legislation cannot be tested or cannot be defended, my lord, by a reference to the subordinate rules which are framed by the state and are not legislative in character in the sense that they cannot be elevated to the status of a plenary legislation. Question of repugnancy, my lord, arises. Question of repugnancy does not arise in the context of a subordinate legislation. Question of repugnancy always arises in the context of a plenary legislation. In the context, my lord, of the subordinate rules, the challenge is on the ground that either it is ultra-vires, or that it violates a parent statute, or it violates Part 3 or any other constitutional provision. Repugnancy question, a test of repugnancy always arises in the context of a plenary law. And that is what is being put forth.
Yeah.
My lords, if your lordships kindly come to, my lord, this is one aspect of it, and therefore, my lord, read with the rules as it now stands, or, my lord, which rules according, as your lordships were observed, pleased to observe, have made a seminal change from the rules which were there under the 2009 Act, will really not take the argument forward insofar as, my lord, the question of repugnancy is concerned. If the provisions of the Act, because after all, my lord, it is under the amended provisions of the Act that the rules are framed. No, my lord, if I want to challenge the rules, I can possibly challenge the rules. If I want to challenge, my lord, the conduct in which, manner in which, my lord, Jallikattu is now being conducted from year to year, specific instances, probably, my lord, I could do it. But my lord, when I challenge the rules, and the rules are propped up by saying that these are not ultra vires the provisions of the Act, then my lord, I'll have to show specific instances where the provisions of the rules have been violated. But that is not, my lord, an argument on repugnancy. In my respectful submission, 254, argument of repugnancy, judicial usurpation of judicial power, legislative usurpation of judicial power. These are all, my lord, have been laid down by your lordships only in the context of a plenary law versus a plenary.
Yeah.
Not in the context, my lord, of rules which are framed, subordinate rules which are framed, and my lord, which have to be tested on the anvil, which I just now, my lord, submit before your lord.
Yeah.
No, my lord, the further argument, my lord, I'm hurrying, my lord, because your lordships have said this. I just wanted to present what I respectfully submit would be a different facet to this. No, my lord, if your lordships kindly come to the PC Act, kindly have a look at the PC Act, my lord, the PC Act. Lordships have been taken through the objects and reasons of the main Central Act. When your lordships read the Prevention of Cruelty to Animals Act, your lordships would obviously have in mind entry 17 of list 3, which says prevention of cruelty to animals. That is what this act is intended to be. And that is what, my lord, it states in the statement of objects and reasons as well.
Yeah.
But please come, my lord, to section 3. Once your lordships read the main act, it shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. Added to it is the Tamil Nadu amendment which is under challenge, notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations as may be framed by the state government shall be permitted. No, my lord, this is one. No, my lord, this by itself, my lord, would probably be inadequate. Therefore, my lord, they come to section 11.
Yeah.
Now, if your lordships have a look at section 11, 11.1 deals with treating animals cruelly. Each one of the subsections, my lord, of subclauses of subsection 1, beats, kicks, overrides, overdrives, overloads, tortures, etc., etc. Each one of them, my lord, has been treated as statutorily treated as acts amounting to cruelty. Each one of them.
Yeah.
No, my lord, then your lordships will come to subsection 3 because the amendment is in subsection 3. Amendment is not to section 11.1.
Yeah.
What therefore the Central Act behoves as acts amounting to cruelty in treatment of animals remains as treating animals cruelly.
One thing, sir, preparing for the state, is there power conferred on the state to make rules after the even your amendment?
Yes, my lord, only subsection 2 or section 3.
The amendment made to this main act,
By Tamil Nadu?
Tamil Nadu itself says that subject to the rules framed by the state government.
No. Whether section 38 deals with the rule-making powers being conferred on the central government. Have you amended the Prevention of Cruelty Act?
Yes, we have.
By which may be made on the rules may be made by the state.
Yes.
Where is it?
Lord, the Maharashtra has brought in section 38B.
That's right.
Tamil Nadu has not done. Therefore, my lord, they apparently would trace the source.
If you have not made amendment to the rule.
It's only under section 3.2 which says rules and regulations as may be prescribed. But if your lordship says, yes.
Power is conferred under section 38 on the central government. Yes. By a central act.
And
it is in the concurrent list. Therefore, you have the power to amend the act.
And section 3, which has been added but not amended,
yeah,
that itself provides that the state
that doesn't confer the power to make rules.
It doesn't.
It does, my lord.
I wanted to bring to your lordship's notice.
That does not confer power on you to make rules, which is why the Maharashtra government has in fact specifically amended it. Yes. And rule-making power must be conferred.
Exactly.
Lord, Maharashtra has amended.
Maharashtra, I think that proves the point.
But both Karnataka and Tamil Nadu have not amended 38, that's all. That's not.
If you don't amend the rule, how do you make the rules in the first place? And if you don't make the rules, the package which.
Lord, I checked it. I wanted to make this submission, but I checked it, Lord, the answer.
Section 3, section 3(2).
3(2).
Yes, 3(2).
3(2), huh?
Notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to such rules and regulations that may be framed by the state government shall be permitted.
All right.
Page Muller's 138.
That is true, that your lordships have seen.
That's what my lord asked, Muller. That's very much.
That is something which the lordships have already seen. Whether your
No.
lordships are asking whether
My lord asked.
this is a
the question.
section analogous to section 38B of the Maharashtra.
Doesn't have to be.
That's not there.
Doesn't have to be.
Subject to such rules.
That may be framed by the
state.
That's
But where is the power to frame?
Whether we put the power in 38 or not in either section, Lord, ultimately the power should be there.
That's all.
So that power has been reserved expressly and specifically.
Artfully done.
Yes.
Inartfully done, not.
My lords are right, it could have been, it should have been there also, but with great respect, Lord, where the power is located would not be decisive.
Yes.
My lord, I have not reached it as a ground and therefore, my lord, I have not pursued it further. But this was something which struck me anyway, my lord, I leave it at that.
All right.
Yes. No, my lord, because this they could always tackle by bringing in an ordinance tomorrow saying that amending the section 38 analogous to the manner in which Maharashtra has amended it. It doesn't really cut at the root of the matter, therefore, my lord, I leave it at that.
To take care of that.
Yes. No, my lords, but when your lordships come to section 11(3), nothing in this section shall apply to, my lord, A, the dehorning of cattle, the castration or branding or nose roping of any animal in the prescribed manner, the destruction of stray dogs in lethal chambers, or by such other methods as may be prescribed, the extermination or destruction of any animal under the authority of any other law for the time being. Probably, my lord, there are state laws by which, my lord, stray dogs are to be, the ABC rules have been framed. There are several other laws. Any matter dealt with in chapter 4, or, my lord, C, E, the commission or omission of any act in the course of the destruction or the preparation for destruction of any animal as food for mankind unless such destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. My lord, this clause has been the subject matter of a deep deliberation by this honorable. And therefore, my lord, there is a compendium of rules dealing with slaughtering framed at the state level and also framed, my lord, under the Prevention of Cruelty to Animals Act. Lord, I'll give it is all part of it.
Does it sort of harmonize?
Yes.
With the injunction in the Upanishad that no being can claim superiority over another?
Yes.
Without claiming superiority, obviously you can't catch hold of whatever animal it is.
Yes.
I mean, kill it, whatever is the cruelty involved, cook it, eat it.
Eat it.
So when you're talking about animal rights,
yes,
be reminded that even the lawgiver has contemplated, in a manner of speaking, giving a slightly higher place to a human being. We have subordinated even the lives because we are not cannibals. For example, you don't kill a human being. In case that's what you are like some of the countries perhaps in Africa, even some parts of Africa, they still have it. So we don't do that. But animals are allowed to be cooked. For medicinal purpose, you can do that. In various stages, we'll find that animals are not treated on par with human beings.
This is what I wanted to submit. This is where, my lord, I would respectfully request your lordships to kindly consider this aspect. Subsection 3 of section 11 and subclause E. Therefore, my lords, permits slaughtering of animals for food. The other subclauses,
slaughtering for the purpose of human, my other brother pointed out, for religious purposes, you can slaughter it.
No, religious purposes, my lord, it has not been upheld as part of Article 25. It has not been.
It has been. It is, for example, in Uttarakhand.
No, Bakri, my lord, Bakri. It has not been upheld under Article 25. But assuming, my lord, that it is upheld, it still would be, my lord, part of Article.
Alone in whole part of Eastern India, animal sacrifice.
In all the temples,
sacrifices, my lord, are prohibited. Animal sacrifices have been prohibited under a separate enact.
Animals are being killed, lambs are being killed, offered as sacrifice in the temples in Uttarakhand.
Prohibited activity. It's a prohibited activity.
It is. It was in fact considered by a division bench to be, and all that we said was, the division bench said was, it should be done in a slaughterhouse.
Look, that part of it I understand. Lord, if it is done in a slaughter,
Anyway,
then
the
it
act
comes-
says so. The act
Lord,
says so.
Correct, Lord. Nobody
Act
must.
says so.
Nobody might have challenged.
What
that's a
you're
different
saying is
matter.
the general refrain is that there is a perception that animals are being subordinate to our interests. When you say you can't do it, means you can't do it. That animal has got the equal rights.
That's
Maybe
what
it
I-
is not correct.
That's what I wanted to submit. Therefore, there is a subordination. But why is there a subordination? And why is the subordination not illegal? Because preparation, slaughtering of any animals for the food of the man, again, my lord, is probably propping up the fundamental right of man, my lord, to live under Article 21. It is traceable to Article 21.
And
Therefore, subclause E could be upheld because, my lord, it is in perpetuation or it is in support of the right of man, my lord, to have food, which is part of the right under Article 21, right to live.
why can't man live on land?
No, it cannot, my lord. It's a personal choice. That's a different matter, which is again, my lord, construed as a right of under part of Article 21.
Therefore,
My being a vegetarian or a non-vegetarian is my choice. It's part of my right to privacy. It is part of my right of choice, and therefore it is again be treated as under Article
how
21.
do you show compassion to the animals by killing them?
No, you do not show, but you do it out of necessity, and this is what has been considered, my lord, in Nagaraj also. Each one of the subclauses under subsection 3 comes under the doctrine of necessity and is therefore not supported by that. More so subclause E, which says that because it is food for the man. It's food for the man. There the question that there could be alternate forms of nutrition, which my lord in Qureshi 3, this honorable court said, had my lord had gone deeply into that subject is really not the answer. In my most respectful submission. I have my choice, my lord. I am a vegetarian. I have my choice. But there are persons, my lord, who need meat, my lord, for food, and they have been used to that. They have been used to that for centuries, and that is why, my lord, subclause E under the
Jallikattu is also for centuries.
no, my lord. There is absolutely nothing to show. There is no. That's my lord. That's
Brother Roy put.
Lord,
Going
that my lord put it on a rhetorical basis, if I may say so. I'm not, my lord, trying to put your words in your lordship's mouth. Where your lordship said, somebody wants, my lord, the hand of the very fair daughter of a noble man, and this is the only way of doing it, my lord. I don't know. He could be either completely crazy, or, my lord, he could be a very brave man.
He could be besotted, not
He
crazy.
could be besotted.
Under,
Which means, my lord, another form of craziness.
under which law this animal sacrifice is prohibited for religious purposes?
No, not for religious purposes. Religion, it is, my lord, my lord, I'm only saying about the judgment which
No,
says.
we are asking because there is some indication that it's for animal sacrifice.
Section 28.
Animal sacrifices are not. Animal sacrifices are not expressly permitted, but when it.
Is there any prohibition?
That's, my lord, under the rules. That's under the prevention of cruelty to animals, slaughterhouse rules.
Not 28, section 28.
No, I'll come to section 58. No, that's a different.
Section 20.
Nothing contained in this act shall render it an offence to kill any animal in a manner required by the religion of any community. Then it must be part of an essential religious practice. What I'm saying, my lord, is that killing of an animal, if it is part of an essential religious practice, not only is it sanctioned by 28, it probably, my lord, would therefore be protected by Article 25 also. I'm saying, my lord, that Qureshi held that Bakri or sacrifice of animals, my lord, killing of animals at the time of Bakri is not part of Article 25. Touched it, did not go deep into it, but there is no judge. There are several judgments which says that sacrifice of animals, my lord, it would not be part of an essential, it is not essential part of an essential religious practice. That there are. But that is not it, my lord. If it is, my lord, I am on demurrer. Suppose it is part of an essential religious practice, it gains a protection under Article 25. If it is for food, it gains a protection under Article 21. How does a sport or a sporting event or even culture and heritage, my lord, as it is touted to be, it does not have its moorings under any one of the rights under Part 3. What I've experienced is
Yeah.
No, my lords, if this be the case, then my lords, this is where the repugnancy really arises. The amendment, Tamil Nadu amendment takes it completely out of the purview of the PC Act, because that's what section 11.3 says. The amendment by Tamil Nadu, both in 22, 28, section 3 defining what is a Jallikattu, section 2 defining what is a Jallikattu, 3 says the first part of 3.1 will not apply to a Jallikattu. Then 11.3, none of this will apply to Jallikattu. Then 22, then 28, taking Jallikattu completely out of the purview of the PC Act. This is where the repugnancy to the Central Act, my lord, really arises.
Assent to the president. Answer is very clear. It is because there is repugnancy that there is assent to by the president.
The assent to the president has also been independently challenged. That's a different matter. I'm not touching on that. I'm saying, my lord,
So that
is it
repugnancy go?
my lord, the first question is it repugnant? It is repugnant. Is by
Assume it is repugnant.
yes.
It is saved by the assent
Yes,
given
yes.
by the president.
Yes. No, my lords, the question of repugnancy has also been gone into by now. Though I don't know whether the question of the presidential assent was there under the 2009 Act.
Nagaraja was not on the same fabric. The legislative.
No, it was not on the same
completely
fabric.
changed.
It was not part of the same fabric.
It will be a contradiction in terms to say.
Correct.
that the State legislature does not have the power to amend the.
Correct.
That's why we gave the example. Suppose
Correct.
Parliament amended
Your
it.
lordships are right. Your lordships
Suppose
are right.
Parliament amended it.
Yes. No, my lord.
Better example is there.
Yes.
Yes.
No, Parliament did not amend this.
Supposing, we are telling you, supposing Parliament amended the law and brought in the same amendment
Yes.
that Tamil Nadu brought in,
Yes.
can you say it's still repugnant?
Then the argument isn't right.
Therefore, what you're saying is lack of legislative power, rather lack of legislative power.
Sorry.
All of this is traced to
Sorry.
entry 17, which is in the concurrent list.
No, I'm sorry.
Prevention of cruelty to animals is in the concurrent list.
Yes.
Which means what? Both the parliament and the state can make the laws, amend the laws. There is a law made by parliament, the Cruelty Act. The state legislature amends it. Power is under 17.
Yes.
So how do you say power is not under 17?
No. I'm saying, my lord, I'm not on that. I'm saying that this amendment made now just is not a valid amendment because it amounts to an usurpation of the judicial power of the state. Why?
The argument.
Again, no, I'm sorry, my lord. That's not what I.
Repugnancy at all.
No, my lord. In every case, my lord, of a repugnancy, there possibly could be, my lord, an argument of this nature also. Why I wanted to bring repugnancies for this purpose. 11.3, my lord, each subsection in 11.3, each subsection, a subclause in 11.3 is rooted in some measure on some fundamental right. Not this. Not this. It cannot be on culture and heritage and definitely not a fundamental right. If it comes under Article 51GH, all right, my lord, the directive principles of state policy say that you should encourage it. But where is, my lord, the material to show that Jallikattu is part of the culture and heritage of the state from time immemorial? It is not there.
Yeah, understood you.
No, my lords, there are two judgments, my lord, which your lordships must have seen innumerable times when it comes to, my lord, usurpation of judicial power. No, my lord, before your lordships get into that, there is one judgment on colorable legislation. Locus classicus, and the one paragraph on that, if your lordships kindly have a look at 1954 SCR 1, Gajapati Narayan Dev versus State of Orissa. But it's not part of the compilation. The list has been.
Who is the author of this judgment?
My lord, Justice Mukherjee, Justice B.K. Mukherjee.
The reference to that ECO, that US decision, is checked. Chinese laundryman case. Anyway, if it's not.
No, I don't think so. No, but the nominal citation is not always good. Lord, I'll check upon that your lordships are having.
No, that was one of the initial authority one.
Yes, it still remains.
The Chinese laundryman case, US Supreme Court. Anyway.
Yes. My lord, just paragraph 9. Just permit me to read paragraph 9. I'll just take 2 minutes on.
Yeah.
Para 9, my lord, I think the paragraphs are the same. I hope so, my lord, because I got a SEC copy of an SCR judgment.
Yeah.
It starts with, it may be made clear at the outset.
You have to read slowly because I am not having.
Oh, I'm sorry. I can give, I can
No,
handle
you
it.
can, I'll follow you. Please.
No, no. My lord, it's, sorry.
You'll have to tell us how it begins because SCR as
My lord, it begins by saying,
No
it may
paragraph.
be made clear at the outset.
Yes. Page 10.
My lord's got it. My lord, the paragraph. SCR copies may not be paragraph.
No, no,
paragraphs may not be numbered.
No
Page
paragraph.
10, page 10.
But your lordship got the paragraph.
Page 10.
Yes.
And we got the para out. Please read.
It may be made clear at the outset that the doctrine of colorable legislation does not involve any question of bona fides or malefides on the part of the legislature. The whole doctrine resolves itself into the question of competence of a particular legislature to enact a particular law. If the legislature is competent to pass a particular law, the motives which impelled it to act are really irrelevant. On the other hand, if the legislature lacks competence, the question of motive does not arise at all. Whether a statute is constitutional or not is thus always a question of power. A distinction, however, exists between a legislature which is legally omnipotent like the British Parliament and the laws promulgated by it which could not be challenged on the ground of incompetence, and a legislature which enjoys only a limited or a qualified jurisdiction. If the constitution of a state distributes the legislative powers among different bodies, which have to act within their respective spheres, marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect to the subject matter of the statute or in the method of enacting it, transgress the limits of its constitutional powers. Such transgression may be patent, manifest, or direct, but it may also be disguised, covered, and indirect, and it is to this latter class of cases that the expression colorable legislation has been applied in certain judicial pronouncements. The idea conveyed by the expression is that although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality, it transgressed these powers, the transgression being veiled by what appears on a proper examination to be a mere pretense or a disguise. As was said by Justice Duff, in so and so, where the lawmaking authorities of a limited or a qualified character, it may be necessary to examine with some strictness the substance of the legislation for the purpose of determining what is that the legislature is really doing. My lord, I'll stop here for a moment. But then, in other words, it is the substance of the act that is material and not merely the form or outward appearance. And the subject matter and substance is something which is beyond the powers of the legislature to legislate upon. The form in which the law is clothed would not save it from condemnation. No, my lords, please keep this judgment by your lordship's side. No, my lord, Prevention of Cruelty to Animals Act, my lord, fortunately, is under entry 17 of list 3. Entry 17 of list 3, please have a wording of it. First time that your lordships are really, I believe first time that your lordships are really concerned with the state amendment, my lord, to the Prevention of Cruelty to Animals. I'm not sure, my lord. First time. Now, my lord, in 7th schedule, entry 17 of list 3. My lord, it reads as prevention of cruelty to animals. That is how the act is also worded. A state amendment, my lord, to the entire act within itself, my lord, will be slotted under entry 17. A state amendment, my lords, which essentially permits Jallikattu to be taken out of the purview, my lord, of the main act. How does it, my lord, flaunt itself as an act which could come under prevention of cruelty to animals? That's a question which I asked him to myself. Prevention of Cruelty to Animals Act 1960, the Central Act is clearly slotted under entry 17.
We'll give an example by way of answer to what you are saying. Supposing the original, that is 11.3,
Yes.
A to E was already there. Assume that A to C was there and they wanted to add D and E later. Now what is E? E permits killing of animals for the purpose of eating it.
Rooted in 21.
No, whatever it is.
Rooted in 21, my lord.
Yeah,
That's why
we are talking about, see, the point is this. We have a division of legislative power, as you know. List 1, list 2, list 3. In the case of a state making a law, it can make it either if it falls under list 2 or it falls under list 3. Now, if it falls under list 2, then the state will have its way subject to Article 246.2, 246.3. Because it's subject to, in the case of any. In the case of a concurrent list, alone repugnancy can arise. It has been laid down.
There's one caveat.
And once there is repugnancy, it can be saved under 254.2 qua the particular state on the receipt of assent. The doctrine of colorable legislation, which you have been harping upon, relates to a conflict between a law which is made by the state legislature, pretending as if it is trying to make it under a list in list 2.
That's a classic test.
That's the test.
That's a classic test.
So if it is falling, therefore the first step you have to take is whether the law is traceable to which list. Once you find that it falls in list 3, the next thing you have to do is whether there is repugnancy. Third thing, if there is repugnancy, has President given the assent? Correct? In this case,
yes,
you should realize one more thing. The earlier
Nagaraj.
Okay. The judgment was dealing with a case of repugnancy where the state tried to put it under various state lists. It failed. This court took the view that what you're trying to do really is something which is covered by the Central Act under the Prevention Act. So impliedly the court was recognizing that if they wanted to do something of the kind which they have actually got around to doing later on in 2017, it would appropriately, properly fall within the ambit of entry 17 of list 3. So they went about doing it, and they knew that it is repugnant. Since it was repugnant, in tune with 254.2, they got assent to the president. So it's all on the, face of it, it's all very good. You may have other arguments which we are prepared to hearken to.
Can you respond? The argument, my lord, that was taken up before Nagaraj by the state were two, three, four.
Yes.
One was, my lord, that it is within the competence of the state legislature. On repugnancy, they said there is no repugnancy. This is different.
Thanks.
Entry 17 was referred to by the court while dealing with Nagaraj also. Ultimately, my lord, the legislation is sourced to entry 17. It is not sourced to entry 14 and 15 of list 2. Though that argument was advanced, it was specifically rejected both in the main judgment as well as in the order dismissing the review. Now, but the point is this. Lordships asked me whether, suppose a parliament had enacted this law, now that the state has done it, but hypothetically, suppose a parliament had done it, would this argument of colorable legislation, apply at all? An argument of colorable legislation cannot really apply, cannot be taken up except in respect of matters which specifically come under list even regarding any parliamentary legislation. Regarding any parliamentary legislation, the question of competence can be taken up or it can be raised as an argument only when the legislation otherwise squarely falls under list 2. Otherwise, when either under list 3 or under the residuary article of list 1, it is open to the parliament to bring about any law. Well, the classic example is before Constitution was amended in 97A, entry was imported. The Finance Act was always sought to be supported. Mr. Sibyl would know that very well. Was sought to be supported with reference to the residual entry. Therefore, the parameters which your lordships would always employ in considering a colorable legislation, when it comes to a parliamentary law and when it comes to a state law, are different. My submission is that I just put what is a colorable legislation. But the argument is this, and this argument your lordships may consider. This law, which purport itself to be an amendment, my lord, to the PCE Act, and PCE Act being squarely, my lord, for the purpose of preventing cruelty to animals. That's the whole object of the Prevention of Cruelty
That is
to Animals
not,
Act.
that is not. Please read, take the object of that act.
Yes.
The Prevention of Cruelty Act, please read that.
Yes.
An act to prevent infliction of unnecessary pain
Yes.
or suffering
Yes.
on animals.
Yes.
Next is relevant.
Yes.
And for that purpose,
Yes.
to amend the law relating to prevention of cruelty act.
That's a central act.
So not for the purpose of exclusively or totally to prevent. So that is the first part. The first part says to prevent infliction of unnecessary pain or suffering of animal.
No.
So this law was enacted to prevent that.
That's because there was an earlier. There was an earlier law.
We already said the Prevention of Cruelty Act, Animals Act 1960. This was enacted for that purpose.
No, my lord, the first part of the preamble is referable to what your lordships will get it under section 11 and section 11.3. This is a manner in which, my lord, preventing and unnecessary pain and suffering, your lordships will find it in every clause here, even in E, which permits slaughtering of animals. Unnecessary pain and suffering, your lordships will find it there. The Act regulates it.
That was it.
The Act regulates it, Lord. That is why your lordships will find
Not
a
for total prevention of cruelty.
No, not the.
Because see, for the purpose of invention, to aid invention, if that is used, that will not be treated as for the purpose of cruelty.
Fair enough, my lord. Unnecessary, to prevent unnecessary pain and suffering.
That is why it
What could be, my lord, is conduct of Jallikattu, which involves, my lord, as this honorable court has found, inflicting pain and suffering on bulls. Can it be treated, my lord, as something a necessary concomitant of, or can it be treated as a necessary pain or suffering that the animal may undergo? It cannot be. Sorry.
Our request. These questions have been already raised by Mr. Diwan very extensively.
Very,
And we'll call upon them.
very,
Anything you want
very
to add for them,
no.
added.
No, my lords, this is one.
At the same circle.
No, I'm sorry.
So this very repugnancy submissions, abuse of the legislative power exercised by the government, it is not within the scope of the ambit of the Act of 60. It has already been argued at length.
Except that, my lord, I wanted to show to your lordships 11.3 and show it that the permission that is granted under the central.
11.3 has been very extensively argued by Mr. Diwan.
Not, my lord, not with reference to Article 21. Not with reference to Article 20. That's what I wanted to, my lord. It's only another facet of the argument. It's another facet of the argument.
To give audience to all lawyers.
No, my lord.
The question is,
I'm
to add something to what has been argued.
I'm concluding in 10 minutes.
Okay.
I'm submitting, my lord, that in 11.3, why, my lord, slaughtering of animals is also governed by the provisions of the PCA Act. It's an act, my lord, to prevent cruelty of animals, prevention of cruelty to animals. But nevertheless, my lord, it also regulates the slaughtering of animals. It's prevented. That's a plenary legislation which deals with, my lord, slaughtering of animals. That is, my lord, because it is slaughtering of animals is permitted because it's food to mankind. And when it becomes part of the food, it is traceable to the man's right, my lord, under Article 21. That is why, my lord, it would gel with the general scheme of the Act, which is for the purpose of preventing cruelty to animals. The ultimate cruelty that one can inflict upon an animal is what? To slaughter it. But that is permissible because it is for food. That isn't gel with the general scheme of the Act. My submission is this. Keep that apart. Every provision in the main Act which says that slaughtering, or which says, my lord, that pain and suffering, as your lordships put it, unnecessary pain and suffering apart, that there could be pain and suffering that the animals could be subjected to, including slaughtering, is because there is a justification on a higher pedestal. That is why, my lord, 11.3 cannot be found fault with. 11.3E cannot be found fault with because it is traceable to Article 21. The submission, my lord, the sequitur is this. On what higher right can, my lord, the conduct of Jallikattu be rested on? Is it culture and heritage? What is the material? One. Secondly, culture and heritage was touted before Nagaraj, before the honorable court in Nagaraj, as, my lord, as something which, my lord, justifies the legislation. Even in there, that's the same thing here. The format is different. No material whatsoever.
So indirectly you are saying about this is an avoidable pain. Are you?
Yes. One, it is an avoidable pain. Secondly, it is not, this conduct of Jallikattu cannot be rested on the achievement or exercise of any right which is higher to that which is already recognized, my lord, under the Prevention of Cruelty to Animals Act. You have the legislative, my lord, device by taking it completely out of the purview of the PC Act. Prevention of Cruelty to Animals Act squarely falls within entry 17 of list 3. You can't bring in an state amendment apart from the question of repugnancy. That's why, my lord, I submit. Whether could it be done, my lord, by the parliament? I'm saying, my lord, that insofar as the parliament is concerned, probably the residual entry will come and support that. But even then, insofar as the state legislature is concerned, we are concerned with that. Insofar as the state legislature is concerned, it doesn't fall, it cannot be slotted under entry 17 of list 3. And the legislation is therefore bad even for that reason. Yes. Every exception that is carved out under the Prevention of Corruption Act has its roots or is predicated on the exercise of some right or the preservation of some right which can be put on a higher pedestal than, my lord, the preservation of animals' rights or, my lord, avoiding unnecessary pain and suffering to an animal.
Yes.
This is my respectful submission. Yes. Now, my lord, on the question, my lord, I'm cutting it short. My lord, on the question of what could be the parameters, my lord, that have to be applied in relation to a validating act. My lord, I'll just give the citations and then, my lord, say what the principle is. My lord, the first one, my lord, is the original judgment of Prithvi Cotton Mills versus Brochborough Municipality, 1969, 2 SEC 283.
Yes.
Paragraph 4. Lord, I'm not reading it. Lords might have read it several innumerable times. 16. Lord, 69 2 SEC 283. Paragraph 4. Then, my lord, there is a detailed analysis of the same principle, my lord, reiterating what was mentioned in Prithvi Cotton in 97 1 SEC 326 paragraph.
It's the same proposition, if the latest for the earliest.
Sorry,
The same proposition.
No. I'm just giving the paragraph. I'm not reading it. Therefore, I don't want to take up your lordship's time. Yes, and the last one, my lord.
Taking our time, but
No.
in practice.
Yes. But
The parent.
no, I'm not reading anything.
Yes.
The last judgment, my lord, which gives a conspect of all the earlier judgments on that point is 2003 5 SEC 23, paragraph 17 and 20 to 22. The nominal citation, judgment by Justice Romapal, National Agriculture Cooperative versus Union of India. My lord, the test is this.
3, 5.
One manner in which, my lord, you are not.
Repeat that page.
Page, my lord, the 2003 5 SEC 23, paragraph 17, 20 to 22. Lord, the test is only this. Has the basis of the earlier judgment been removed by this amendment? Assuming that it has removed it, is it still constitutionally valid? Is it within competence of the legislature? My lord, these are the normal parameters that are my lord, applied.
Yeah.
Whenever, my lord, an act of this nature, my lord, is challenged before your lordships. In my respectful submission, my lords, the finding in Nagaraj that Jallikattu inflicts cruelty upon animals is not a judgment which is predicated merely on the construction of the provisions of the act that was my lord,
Inherently cruel.
inherently. Yes. In which case, my lord, no amount of legislative engineering by bringing in a legislation which is a state amendment and getting a presidential assent is sufficient to get over it. My lord, the test is this. Had this amendment been available, my lord, to the bench, been before the bench when Nagaraj was delivered, would the judgment have been the same? The reasonings might have been diverse. But this reasoning, that Jallikattu by itself inflicts unnecessary pain and suffering on the animals, that finding would have still been missing. That cannot be removed and that has not been sought to be removed. That is not on the construction of the provisions of the Prevention of Cruelty to Animals Act alone. It is, my lord, an appraisal of what the event entails. It is on an appraisal of the factual situation that was pleaded by both sides. And that is why, my lord, it is therefore elevated to the status of an adjudicated fact.
Yeah, understood.
This, my lord, this is my respectful submission.
Thank you. Thank you. Who else is going to argue? Thank you.
My lords, can I just give the paragraph numbers and then, my lord, or if your lordships have already noted the relevant paragraphs in
Of
Nagaraj.
Yep,
Your lordships have noted.
number of times.
3 to 56.
That's on the question of.
43 also, 43 also.
Yes, yes.
From
You have to
40.
read,
Yes.
you have to read each and every.
My lord, the behavior of the bulls and all, my lord, your lordship
Everything is
will be
there.
reading it anyway. My lord, let me not restrict your lordship's appraisal of Nagaraj only to certain paragraphs your lordships have considered.
Thank you.
My lord, I'm deeply grateful to you. Lord, I hope I did not test your lordship's faith.
No, in fact, so now we'll have, who's arguing?
Very well. Grateful to you.
You are for Mr. Grover?
Lord, I am
Lord, that
for a-
judgment that China, that's in paragraph 11 of the 19th.
Yes.
Lordships were referring to that.
The import, Chinese bond demand.
Para 11 of the same judgment. Professor.
Okay, so I guessed correct.
This is how we remember judgments.
Lord, I am for 3 writ petitioners, Lord, and the name of the organization is called FIAPO, Federation of India.
That's all right. What is the number of the petition?
The numbers are 27 of 2016, 6 of 2018,
Okay.
and 10 of 2018. Each one of them will individually challenge.
6 of 18, 10 of 18.
600.
Each one of them individually challenge the 3 laws. Lord, I am going to give on slightly different points. Mr. Shandiva did an excellent presentation, but he actually consciously gave up the issue of animal rights and whether they are amenable to protection under 21. Lord, I'm not going to argue the extreme position that they are covered as persons within the meaning of Article 21. There are lots of questions that actually fallen from the bench. I'll attempt to answer them. So the first point will be, Lord, if I may say so, the notion of dignity in Article 21, which Nagaraja actually places a very, very important place for animals. Lord, may I just say this, Lord? Nagaraja is a judgment of seminal importance because it elevates the rights of animals from zero property.
Correct.
Lord, I want to, if your lordships will, Lord, this is because I don't want your lordships to hold that portion of Nagaraja, which Mr. Chandivan rightly, because he didn't want to argue that. It's like a batsman saying, I'll score 6 instead of 4, not because he doesn't agree with it. But I want to emphasize that dignity in Nagaraja is akin to what Francis Coralie Moulin did in embarking on dignity in 21. Let me just emphasize why. Look, prior to Francis Coralie Moulin, of course, your lordships have already noticed from R.C. Cooper, Menaka Gandhi, how 1914 actually changed from just being procedure established by law to fair, just and reasonable substantive law. That's important. But what this did, Lord, it's very important to appreciate what Francis Coralie Moulin did, because 21 is the classical negative covenant on the state. Please appreciate this.
Yeah.
It's essentially what is known in international law, a civil and political right. Just an addition on what is called the theory of progressive realization and non-retrogression. Classically, at international law, after the Universal Declaration of Human Rights, there is a division, partly because of political reasons, between the international covenant on civil and political rights, which are replicated in our chapter 3, in our constitution, fundamental rights, and the economic, social, and cultural rights covenant, which are actually reflected in the directive principles. Both are borrowed from the UDHR.
Yeah.
Now, my lord, 21 is a classical negative right. What did Francis Corrali Mullin do? I'm very short.
Over one thing, whose right you are talking about here?
I'm talking about animals' right. I told you, Lordship, I'll answer that. I'm conscious of what my Lord Justice Kumar, your Lordships, my Lord Justice Rishikesh Roy, all the 5 judges have put this question. So I'm going to answer that in a short summary manner, my Lord, because your Lordships have limited us in time. I'm going to argue that 21 is invocable. Not through the conduit, as Mr. Shandivan said, through the injury to the person, human being. Because, nomenclature wise, animals include human beings. We are not talking about biological definition, we are talking about a legal definition, what is personal. But let me just not emphasize this, because let us not lose the sight of the fact that Nagaraja actually made a change towards the betterment. And why, Lord? And I'm giving an example of Francis Corrali Mullin because it also changed the whole notion of fundamental rights. Because prior to Francis Corrali Mullin, 21 was a purely negative covenant. Procedure established by law, life and liberty cannot be taken away. After that, what happened? Moment dignity was introduced. See the power of dignity, beloved. Dignity is an elusive concept, but it is everywhere. It's everywhere. And it actually is the underlying notion of everything, of every right. Not only fundamental right. Respect, autonomy is underlying notion of all fundamentals and human rights. But it is not defined. It is not doesn't have a specific mention. Now, after Francis Corrali Mullin, because we introduced dignity, what happened was, and in that case, it was the access to literature, etc. What happened was, your lordships, in your lordship's jurisdiction, under 32 or 36, etc., conferred a positive right. Positive right of what? Right to food, right to environment, etc. It was unheard of, that sort of interpretation. So please appreciate one thing. When we interpret any provision of the Constitution, it has to be expansive, liberal, and it actually fundamentally changes the notion of what happens. That is also what Nagaraja did. When it introduced dignity, what did it do, Lord? It didn't say, and my Lord Justice Radhakrishnan has been very careful in actually trying to balance the rights of human beings, and my Lord Justice Joseph said, rightly, that the scheme of the PC Act and what Justice Radhakrishnan notes is, in fact, the relationship between humans, animals, and environment. And that is continuously evolving. Now, let me give another example. I want to emphasize this. When the Portuguese invaded Latin America, there was a debate in Portugal. They were treated as slaves. They had a high culture, better than Portugal. But they were treated as slaves. There was a debate in the Portuguese, of course, in Portugal and basically in the church. Are these Native Americans, as we call them now, entitled to be treated as human beings? And there was a particular priest who worked with Native Americans. He said they're entitled to be human beings and they have some rights. The other side said no, they're like animals, they have no rights, therefore they can be slaves. Bartholomew de las Casas argued that no, they are incipient human beings. They are like children. What I'm trying to tell you, Lordship, is after that, slavery was abolished. Things changed. Our notion of human beings has changed over centuries. Our notion of animals are changing over a period of time. So this is actually an evolutionary process where things are changing. Let's not be fixed in time space and assume that the rights that were actually accorded to animals will continue to be there for the rest of time. So today, my Lord, we know certain things about animals. As Mr. Shamdivan has pointed out, they are sentient human beings. They can feel emotion. They can feel pain. They can feel heat. Therefore, they are similar to us and they have a place in nature. The place in nature is crucial to us as human beings. their place in the environment and consequently the role they play in the environment, going human beings is crucial for the survival of the human race. It's that pedestal your lordship will look at it, not in the pedestal of just Jallikattu. When we talk of animal rights are no longer in the species of property for human beings. That's the point of departure. So my point is, first, that your lordships look at this case not as an ordinary case. It's a case in the course of evolution of how we treat animals in the constitutional scheme of things. Now, Lord, I want to read a few passages from Nagaraja. I won't take, my Lord, Justice Joseph has put a guillotine, and I appreciate that, Lord. I wish only, Lord, my only wish is this, Lord. When the matter starts, the Lordship put a time guillotine to NIT. Otherwise, Lord, what happens is, I tell you, Lordship, very candidly, at the bar, there is a jostling for number 1 position, number 2, and number 5 or 6 don't have time. I'm not blaming anybody. But I wish your lordship will actually say everybody is going to go get an hour. And then, of course, your lordships have discretion to say, no, we want to hear, because your lordships are querying.
All that we are saying is that, there need not be repetition.
I want.
What?
Absolutely.
Otherwise,
Absolutely. If there's one word of repetition, the lordship will do a
your
stop.
point, you can definitely say. Otherwise, just say you have to adopt it.
I agree with you. I agree with your lordship on that. That's why not a word of repetition from my side. Where I am actually following the arguments, and I actually adopt the arguments of Mr. Shamniwal, Mr. Luthra, and Mr. Giri Millard. But I wanted to just say, I wanted to point out passages from Nagaraja, Millard, if your lordships will allow me, and I won't read some of them because though they have not been read, I don't want to waste your lordship's time. Please come to Millard, para 61 of all the other passages have been read. I'm not going to read any of them, and I'm not going to read even the ones I'm relying on, just allude to them. Para 61. When we look at the rights of animals from the national and international perspective, what emerges is that every species has an inherent right to live. Now, this is a very important statement, Manoj. Otherwise, if they were just properties, they would not have the right to live and shall be protected by law. Now, please note the next, subject to the exceptions provided out of necessity. Necessity is one of the doctrines which the court has adopted. So they are not entitled to full rights. Animals also have the honor and dignity which cannot be arbitrarily deprived of. And the rights and privacy have to be respected and protected from unlawful practice. This is, in summary, what my Lord Justice Radhakrishnan, in a seminal judgment, put forward as an advancement of the rights of animals. Then, my Lord, there is this declaration of animal welfare. I'm not going to read it, but your lordships have noted in 64, it has been read, the 5 freedoms. My only point I want to make, my Lord, is that, again, in the context of our constitutional jurisprudence, dignity is an underlying concept. Please appreciate that. So, all the 5 freedoms.
Mr. Grover,
My Lord.
the last sentence of paragraph 61.
My Lord.
Animals has also honor and dignity which cannot be arbitrarily deprived of and have to be respected and protected from unlawful attacks. Now, can it be projected that what is being done there is an unlawful attack?
In Jallikattu.
That's right.
But may I answer that later on, because this is a
sure.
very important point.
You go ahead.
I'm glad your lordship has raised it.
Just flagged it.
Yeah, I'll flag it, just put it down there. I don't forget. But I will, because I'm developing my argument, I hope in the course of that will be answered by implication, but I'll also explicitly answer that. Now, please come to 64. What I'm pointing out, I'm not reading out the 5 freedoms. They are based on the underlying concept of dignity. So, freedom from hunger and thirst, all these and more, my Lord, are based on that. Then, my Lord, please note, what my Lord Justice Radhakrishnan does is he says that, look, though we have a statute, the statute actually is in sync with this notion, para 66. rights guaranteed to the animals under 311 who are only statutory rights, the same have to be elevated to the status of fundamental rights. This is a wish, Milan. I'm not saying this is a law, as have been done by few countries around the world, so as to secure their honor and dignity. Honor and dignity of animals is actually the underlying theme. That is very important. Rights and freedoms guaranteed to the animals under 311 have to be read along with 51 AGH of the Constitution, which is the Magna Carta. Now, therefore, you read PCAA and 11 and 3 in sync and under fundamental rights, under directive principles. Then your Lordship has seen that compassion is one aspect, humanism is the other aspect in 68, and speciesism. Now, this is important because how animal rights welfare has evolved is important. Speciesism is a concept coined by Richard Ryder in various works on the attitude to animals, like so and so, etc., defines the term of the assumption of human superiority over other creatures, leading to the exploitation of animals. So the classical view is, like it was even in Latin America, that we exploit others for our benefit. That was the view. Things are changing because we have seen how degradation, treating animals in this manner, degradation of the environment, is actually inimical to the human race. So things are evolving. We have to build new concepts. So my lords, I would request your lordship to see that in that view, in an evolutionary view. Speciesism is also described as the widespread discrimination that is practiced by man against other species. That is a prejudice or attitude of bias towards the interests of members of one species and against those members. Speciesism as a concept used to be compared with racism and sexism on the ground that those refer to discrimination tend to promote or encourage domination and exploitation of members of one group by the other. So the analogy is you exploit black people, Native American, gender, etc., and that is analogical to animals. These things have changed. Why not this? And this is more important because ultimately we have to live together. Human beings, animals, and the environment and the forest are one unison whole. That's the point. Then your lordship will come. One school of thought is that casteism, racism, and sexism are biological classifications since they are concerned with the physical characteristics such as discrimination on the ground of caste, creed, religion, color of skin, reproductive role rather than with physical properties such as capacity for being harmed. Lord, I don't know if your lordship remembers, in the early part of the last century, there were psychologists and psychiatrists who actually propounded theories, Jensen, etc. They measured the skull of Africans and they argued that white men are mentally superior than black. And they were trying to use this is a huge thing till the 60s, till I was in university in the 70s. That was being propounded. And it was the underlying basis of Nazism. So what the analogy is very apt. That how you treated other human beings because of various factors, because you have better facilities in terms of travel, weaponry, etc., and you dominated other communities, and you try to argue that other communities are in fact inferior. Similar analogical theories were propounded for animals, and that is undergoing evolution. Now come to 70 million. We have got over those inequalities like casteism, racism, sexism, etc., through constitutional and statutory amendments like Article 14 to 17, etc., etc. So far as animals are concerned, Section 3 of the Act confers rights on animals and also rights under Section 11 not to be subjected to cruelty. Now, the first answer is, therefore, animals have statutory rights. So there is no question about it. The PC Act itself says that there are rights. So there are statutory rights. I'm going to develop this argument further to say they have rights which are based on dignity, which are constitutional rights. Let me develop it.
We are waiting for development now.
I'm sorry, Lord.
Come out of development. Judgment has been gone through.
No, no, this has not been
Make your
argued
submission.
at all. Please, let me,
Grover, make your submission straight away.
I will. Just let me read one paragraph. One paragraph, which has not been read to your lordships.
Grover, we can't go from the paragraph 1 to the last paragraph of the judgment.
I'm not, if some, not,
You make your submission straight away. What
no,
do you
no,
want
it's
to add?
not. I'm going to argue that what is in Nagaraja is to be preserved. And I want to allude your lordship to that. Just give me 2 minutes. But I will, I'm not repeating, but once your lordship has said this, I will not,
Tell us
I'm not going to read
what
para
option we
70.
have.
But I only read para 71,
We
70.
can only make a
Very
request.
71 and 70, your lordship. We have, however, a lot of, why I'm saying this is slightly different. There are what are called non-essential activities. That's what I want to point out, because when your lordships will balance Jallikattu, the right of so-called cultural rights, which I don't think exist. I'm not going to argue that extensively. And the dignity of animals. If unnecessary pain is being foisted upon them, then your lordship will actually hold in favor of animals. So the balancing is
I've
important.
understood that point.
Very well. I will not read.
That is why the other question was also put avoidable because it is.
Yes, your lordship was right.
Paragraph 71, it is there. It is realizing that that question was put.
Correct.
Not as if we are not.
No, I know. In fact, I noted what my Lord Justice Kumar said. But then only let me read 72. Only, sir. 72.
Gives a dignity, not essential. We have noted.
Yeah, right to life. Now, this is the crucial paragraph. Let me read just 72 and we'll stop at Nagaraj.
Why don't you develop without reference to just give us a
No,
paragraph
I want to.
and tell us. We can
Very well, very well. Your lordship.
Otherwise, it will not be over.
No, it'll be over. My lord. I will
No,
be.
not today. I mean, we are talking about others. We intend to complete the petitioner side for Maharashtra, Karnataka. You must realize that also.
No, I appreciate it. That's why I said at the outset. So, my respectful submission is 72 actually mentions
All right.
what the right to life is.
Para 72, 77.
Yeah.
So, you don't have to read the case.
My lord, now, I'm developing my argument. They host Nagaraja.
Okay.
And Mr. Shamdevan mentioned it, but he stopped at a particular point. I'm not saying animals have the same rights as human beings. This is evolving, and over a period of time, animal rights are actually increasing because we realize that they are necessary for our own survival in the environment, the role they play. Now, their right to dignity is till they are alive. Let me take that as an example, because my Lord Justice Joseph is putting this point repeatedly. Killing to eat is the most cruel form of cruelty. Correct. Like putting a person to death after death penalty has been meted out to that person is also cruel. We accept it. But we say that for human beings, they are entitled to dignity throughout their life, and for human beings, even after their life. They are entitled to decent burial because of Article 21 and cultural and religious things under 25 and 29. As far as animals are concerned, and this is a point of departure and differentiation, they are entitled to dignity of a particular type which will come to till they are alive, but not after they are dead. So the law, because of our understanding and our relationship with animals as it is evolving, posits that we will treat them with dignity, but killing them either for food or for experimental purposes or certain exceptions, they will be killed. So that is the relationship in terms of superiority. Now, therefore, the balancing of rights is an important exercise. There the doctrine of necessity comes in. Is it necessary for us to do certain things? Or, like, for example, experimentation. It's an exception. Now, let me also tell you, lordships, that in terms of drug trials are carried on under phase 1, phase 2, phase 3. In the phase 1, animal toxicity studies are done. That's the norm. We expend animals for the purposes of our betterment. This is changing now. For example, we don't do dissection anymore on a physical animal. We have technologies which allow that to be done without actually touching an animal. But phase 1, phase 2, phase 3, phase 4 trials are on human beings. It's not as if there are no experiments on human beings. I just wanted to point that out. In fact, the drugs and cosmetics and Schedule Y make it very clear that until drug trials are carried on human beings, no drug can be approved. So just that there is an exception doesn't make animal a subordinate person. Now, what sort of rights are the animals entitled to based on the dignity that is bestowed to them? I hope I'm clear that the right to dignity is vested in animals, but it's a different type of right. It's not the dignity that we accord to human beings. What is the meaning of dignity? I teach. So the students ask, what do you mean by dignity? It could be, for example, Lord, I'm arguing. I'm just using myself as a, and your lordships are looking elsewhere. No, lordships are not this. Not that lordships are not this. Suppose your lordships are not listening and ignoring me. I am treated with this respect. Then your lordship will not be treated with dignity. That's one level. The other level is to say you are a useless person. Third would be to beat up a person. So there's different levels. So what is it? First thing is that as far as animals are concerned,
If I know difficulty in making submission, but not on yourself.
very well. That is, I'm getting somewhere. I'm getting somewhere.
Full attention is on you.
No. I hope it's the judge's attention, Lord. And not other people. I mean, this is very important. I'm afraid of these things. I don't know how your lordship treat this, but this is not the.
I think the same reflection is there.
No. I am in jest, Lord. I mean, we are actually subject to now the whole world as an audience and the whole world to criticize us. Now, so, Lord, what is the level of dignity that the animals will be entitled to? First of all, they are not treated as property. So I'm trying to call out things which are different. Then they are entitled to just 5 freedoms because of dignity. I'm just giving examples, Lord, which your lordship.
Mr. Grover, so far we accept your proposition that Article 21 person are interlinked with the environment and animal.
Minds.
But from there, where do you take,
No,
take us to?
The next proposition,
So far as Jallikattu is concerned.
No, I'll come. Because if I had said to your lordship, let me be very candid. The Lord, this arguments are Mr. Sibal knows better than me. There's also a psychological issue, Lord. When we put an extreme proposition, the lordship is rejected. I won't be able to argue anything else. I've learned it from Mr.
I know better than them because I always put extreme propositions. That's my learned friend suggestion.
No, you taught me not to put extreme propositions.
So,
Right, my learned friend is a great teacher, my lords.
Jallikattu is concerned.
So, my lord, I want to put it pithily. This is unnecessary pain.
Only thing is, these are not voluntary action on the part of the animals. They are compelled to do it.
Yeah.
That is one.
One very.
Two, what is
No, my lord, why? Because my lord Justice Ravi Kumar asked on the first day. They have no agency. They are not voluntary because there is no question of volition on part of animals. If they're in their own environment, like for example, the construct of willingness in human beings in law is one, consent is the other. There's no question of those constructs coming in the case of animals.
Now, the law also permits using the animals for human need.
Yes, that's an exception.
They are compelled to do involuntary acts for the benefit of humans.
Correct.
So you want to segregate the nature of benefit, that not the entertainment benefit, but physical benefit. This is what you
I'm not doing it now. Both Nagaraja and the PC Act does it. PC Act to a certain extent.
Yes.
That is exactly what I was trying to read in Nagaraja. This balancing exercise is by the invocation of the doctrine of necessity on the one hand and exceptions on the other. That's the balancing act.
In Nagaraja, the most important one, you read paragraph 71, but not
I
the
didn't
last,
read it.
the last sentence.
No,
The
my
last sentence.
lord,
The last sentence in paragraph 71 is very crucial.
I'll read. May I read that?
It says both anxiety and fear.
Sorry, my lord.
It says, it reads this, like this. Both anxiety and fear therefore play an important role in animal suffering,
Suffering.
which is part and parcel of the events like
Correct. I agree. I wanted to read that, but to deference to my lords, I didn't read it. was time. So my lord, what I'm saying is the overall,
So here our question is, why should it not be left to the lawmakers?
no,
And why should we take ourselves the duty of deciding to what extent we shall extend the
no, there's no question of
necessary,
taking
what is not necessary. All these are all
Lord,
balancing factors.
may I answer that? The law has balanced. Now there is an introduction of an amendment.
But still, that's also law.
No, I'm not disputing that. Of course, I can't dispute it. What I'm saying is that not only your lordships have noted, completely nullifies the Parent Act. Nullifies the Parent Act, but your lordships have to interpret whether in the context of balancing of exercise, is it unnecessary? Is it an exception under the law? Those are the things that your lordships have to look into.
Should we decide what is unnecessary?
Your lordships have, because the unnecessary thing is not defined. It's no, what unnecessary pain is caused? Is it necessary to cause pain to the bulls because of Jallikattu, because of an imagined culture, etc., etc.? Or does the balance go on the other way? If it is not an exception under the law, if it is not necessary under the doctrine of necessity, your lordship will hold in our favor.
Now,
That is it.
I'm
sorry.
That we have already made out, that it's not necessary, we have noted it twice.
No, I'm answering the
No,
question.
no, since you have said, you have noted it, you move on to the next point. Otherwise, what will happen? You have taken it down, dignity. It is not essential. It is not covered by any of the essential means.
No, my Lord Justice Ravi Kumar asked me to read a portion. I have to
Only
read-
said, you stopped it, first part of 71, you have actually brought it to our notice, the last part, you know.
No, both are important. Both are important. Look, my Lord Justice Joseph. Have to be differential to all judges. I can't be.
Eagerly waiting
Yeah,
for you.
now, my Lord, now my next point. Next point is, your lordships are aware that Qureshi, etc., directive principles and fundamental rights are to be in consonance harmoniously. So 51A G
Yes.
is an important part. So when you're talking of dignity, the question will be, if your lordships accept that animals have a right to dignity, then where is it situated? Is it in 51 AG? I would say that it is situated in 21. Because that your lordships have already held. So 51 AG read with dignity have to be actually read into 2022. So that is the next point.
To be read into 21.
Yes, 50 AMG read into 21 is not a problem. But dignity accorded to human beings in 51 AG will have to be read into 21. That's the point. Therefore, my lord, the next point and developing on that is that Article 21, right to life, can be only realized for animals if 51 AG is complied with.
Yeah.
Therefore, compassion, etc. I've already argued on necessity and reasonable. Now, my lord, the last point, which is more difficult for me, which your lordships are waiting for me to. Now, my lord, your lordships are fully aware. Let me just develop it in a minute, my lord. It is protection against life and liberty except by procedure established. Just consider, my lord, for a moment. Today, don't we have all laws to decide how animals have to be slaughtered? So, the horse, the development of 21 before Menaka Gandhi, or even say R.C. Cooper, it was only procedure establishment and not substantive. Today, there is already a plethora of legislations which actually indicate how you can extinguish life of animals. So, my point is that it can be argued reasonably that you cannot deprive a right of life of an animal without procedure establishment, not substantive. I'm not on that right now, only procedural. Even now it is there.
You're contending that the animal is a person, an article.
No. Therefore, I'm sorry, that is the, it's not easy to say it immediately. Let me put it that way, because when we decide, I was thinking this is because it's troubling your lordship, it's troubling me also. I have to be candid to your lordship. This is not all animals are dead to all human rights in 21. No, I'm not saying that. I've already scaled it up. Therefore, one is what Mr. Diwan said, that it is conduited to the human beings. I'm not on that. I'm saying that when you deal with animals, first they have to be respected, they have to be accorded dignity. And when their life and liberty are at stake, that dignity must come in. And I can only situate it under 21. But I'm not saying that everything under 21, which is accorded to human beings in our constitutional jurisprudence, will be accorded to animals. I'm not saying that. But I have to be honest with you, Lordship, I'm struggling on that.
So are you still saying that the animal is a person? We are again asking you.
Yes, I am saying that at one stage we'll have to say that. That depends on the evolution of various technological developments.
Today, as on today, do we have
I'll say partially, yes. I will
enough
say.
material to
Person
declare
includes
that?
animal. Yes.
I'm saying you can, your lordships, in a specific sense, say that animals are entitled to dignity and life and liberty under 21, but scaled down. That's your lordship's interpretation. I'm saying that it should be accorded that.
All right. We have understood you. Yes.
Very well. No, your lordships are understood. I'm not going to. So,
Collateral to 21.
I'm sorry?
Collateral to 21.
Yeah, because, please remember.
Fine, you can.
Even dignity, even privacy in the Puttaswamy case, when we were arguing it, there was a genuine difficulty among judges and lawyers. How do we situate it? And I remember Justice Nariman said, but it can be 19, it can be 21, it can be 14. How do you know it's 21? So it's not an easy task. But I am telling your lordships candidly, I am saying that your lordships, after Justice Radhakrishnan's judgment, will not go back. I won't call it non retrogression because I did an option on that. The theory of progressive realization, doctrine of progressive realization, is actually applicable to what are called economic, social, and political rights, as opposed to civil and political rights. Civil and political rights are directly enforceable. As far as economic, social, they are progressively realizable. As they are realized, you can't go back. That's the only caveat I wanted to add to Mr. Diwan's argument. Now, that's my argument on 21. So I'm stopping it. The second point I want to argue is, the lordship has already seen in terms of the conflict. I'm not getting into that. I want to argue that there is no assent by the president in the manner known to law. And for that, my lord, I thought we had proper pleadings, but I must be candid again to your lordship. One sentence, we have, the draft person has actually put all the points in law, but not said that in this case, there is no assent. So, my lord, I have, with your permission, just added that line as an amendment to the petition. I have to be candid to your lordship. I can't, because this is a constitutional case, I don't want.
But tell us what
Why tell your lordship?
is
The law is very clear. The law is, like any consent, assent by the president has to be informed. If it is informed, you have to tell the president by letter or document that there is a conflict between the state law and the central law. That is, according to us, we reasonably believe it is not done. If it is not done, it is no assent in law. Simple. And there are two known, Mr. Luthra has already cited it. So we're not.
one should presume the presumption in evidence law is that
It is regular, 114 acts are regularly performed.
Yes.
So Mr. Trivedi was, no, you have not contended it. It is contended except the last line that in this case is not contended. So I've taken an amendment out, not one line only. And also I've asked them to produce the documents last week. Produce the documents, show. That's the end of the matter. I don't want anything else. So that's one, judgments, lordships know on that. Just give the two judgments, but I'm not going to read them out. Look, when their turn comes, let them produce. But without production, your lordships will not be satisfied. Look, let me labor on this for a minute, my lord.
So you just give one decision which you want to try on in this.
Yes.
Just one. You don't have to multiply.
Yeah, just, yeah.
Any one which. Any one judgment, please.
Case a hint, your lordship knows.
Just one case law.
Case a hint, my lord.
Just one case. I don't need.
Yes, my lord, 2002 8 SCC 182. Case a hint, your lordship knows. I'll just get your lordship the paragraph.
2008.
2008.
2008 8 SCC 182, my lord.
2008.
Presidential access has to be informed.
What's the
18.
Page
182 at, paras 3, 11, 14, 16 and 20.
All right, we'll see that.
So there's another decision, I'll just cite it, I'm not going to read it, it's very well. It's followed in Balwinder Singh, Balwinder Singh,
All right.
Gram Pachand.
What is the next point?
Now, the next point is that it is according to them cultural practice.
Yeah.
They had argued at the review stage that it is religious practice. That was given up and it was ruled against. Now, they have come up. They should be candid with the court. You can't one time say it's religious practice and the second time change your stance and say, no, it's not religious anymore, it's cultural. They have to be very clear. And 25 and 29 are very separate. Your Lordship knows that is what. They have to affirmatively establish because they are saying as part of cultural practice, and 29 your Lordships are very familiar. Sections of citizens having, I'm not reading it. And then they say that it is to promote native race.
And
Now, my point is they have to affirmatively establish it. One,
they
have to affirmatively establish it. And actually, they can't. Once they've pleaded it's a religious practice, now they shift and they say, no, it's cultural practice. Now, that's one. Secondly, even otherwise, 29 and 29, 21, all the fundamental rights have to be read harmoniously. So even let's assume that there is a cultural practice. Can it lead to the denudation or derogation of the rights in 21 with dignity of animals? It cannot, because the law is very clear on that. That just take an example of sati. There is a cultural practice of sati.
Somebody that portion is read out to us.
Yes.
We cannot have it contrary to.
Correct. Yes. There's only one judgment on that. A portion of the cultural practices which otherwise violates another fundamental right will not survive. That's the point. I'm putting it quickly. Just give the judgment.
What's your next point? Anything else?
No. Yeah. Not on that. AR 2000 SC 2773, para 13.
Yes, what is the point?
Lord, that we have to be harmoniously construed the fundamental. I've already argued that, and I'm just writing the judgment. Now, secondly, 2 more.
Yeah.
1 point won't take long, another point may take a slight time.
Yeah.
Lord, in any event, if your Lordships agree with us, on the ground that Mr. Shamdivan argued, Mr. Luthra argued, Mr. Giri argued, they host my submissions. If the statute is held to be ultra-virus, that's one thing. But a statute always overrides custom. That's the law.
Correct.
So that on that is
Overrides custom.
yeah. Common law, custom law. This is the state said. Now, the final point is on the issue of rules, which is troubling me and troubling your Lordships also.
Grover, give the citation on the.
I'm going to give you 1 minute. No, give me the. I'll just give it,
Yeah, yeah, sure.
we will meet and
Last argument is on.
last argument. No, I am not, I am going to stick to my promise. I am not, Lord, I insist.
Rules.
Yes. But please see the parent acts. It's very important to appreciate the actual rub lies in first amending the act. I'm not reading the sections. And then saying nothing of the cruelty will apply to us. Now, if it is a genuine bona fide and not, I'm not on the colorable legislation. If it was really to prevent cruelty, then they would not say that none of the provisions of 11 apply. The rub is in this, that none of 11 applies. Why? I ask myself this question. Why? Because they know fully well that 11 will apply. Otherwise, why should they do it? We have to see, we have to assume that there is a purpose in 11 being amended. And 11 is being amended because they don't want 11 to apply. And that is the whole part of cruelty. And then they substitute that by mechanisms, only mechanisms which actually are to ensure, but not the core of it. The core is what is specified in section 11. But that is taken away. Then how do we prevent cruelty? We can't even have it by a mechanism. So that's the point I'm making. It's not, I'm not on colorable. Colorable is the Lordship has already said, if entry 17 is being used, and they say, no, it's not 17, but it's actually 14 and 15 of list 2, then it will be colorable. That's what they're doing. I'm not re-arguing on colorable. But here what is happening is, they have taken away all the safe haven. Sorry, they have taken all the action that the government can take on cruelty under section 11 and created a safe haven to perpetuate cruelty, to perpetrate cruelty. That is why it is clear that the purpose is not to actually do a breeding of native breeds or culture, but to actually escape from the liability on the Prevention of Corruption Cruelty Act with cruelty. Now, what they say, only last one, native breeds. Because this is concerned with native breeds. Now, we have come up with reports post Nagaraja. No. They are slim buffaloes. Their size replaced. They have this and that. Whether that's a new fashion. But please appreciate that kind of evidence is not taken into account because this is vested on evidence which is biased. Because you created it for this purpose. Evidence which was the host knowing of this is important. And Tamil Nadu has its own reports on this, which I want to just point out and then stop. Now, just see in my compilation, just give the report. Not compilation, I don't want to burden your lordship. Is it in the compilation? In the convenience compilation by Mr. Justice, by the Mr. Luthra, by us, not in the convenience compilation, we have put a report of Tamil Nadu, which is the number, document 33, volume 33. I want to just not read out, just point out the portion which is very important because the sum and substance is this. And I'll stop with that because if your lordship will allow me to file written submissions later, but I don't want to.
Better that you can do.
Yeah, only one point I want to make. Just keep document 33, my lord. Page number 436, it starts, and it's of the Department of Genetic and Breeding of Tamil Nadu, and they talk of breeds. This will take only 2-3 minutes. Lord, what is it? Yeah, I'm not reading it. I'm not. Those portions, they're at 444, 445, 449, and 524. Now, they specifically refer to the breed or species Jallikattu, which are used for Jallikattu. Specifically, their argument is that in order to preserve the species, Jallikattu is necessary. Now, in this, an independent report not taking into account the litigation, there is not a word of Jallikattu to be used to perpetuate or preserve or conserve these species at all. And well, all other reports which are elsewhere in the convenience compilation, what they say is, why are native species dying? Last one. They are dying because these were draft animals. They were draft animals used to carry goods in the agricultural work. These agriculture work is now replaced by tractors. Therefore, they are not needed anymore. That is the reason of the native species dying. It's got nothing to do with Jallikattu. Therefore, my lords, I'll stop here because your lordships are putting me on guilt.
Thank you.
Citation, de do. Well, that citation, my lord Justice Roy wanted. This is Bimashia versus Janabi, 2006, 13 SEC. Custom is overridden by statute. 2006, 13 SEC 627. Lord, only Millar, I'm so sorry. What do you know?
Yes, who is next?
No, much obliged.
Thank you. Thank you. Who else is there? We take it that Tamil Nadu side is over, going to Maharashtra.
I'm here, my lords.
So you're okay.
My apologies.
We take it you're the.
I am in the very.
You are on entry 97.
No, my lords. Let me just explain my proposition, but I'm on the proposition there's no legislative competence for this law. That's one.
You are which
Your
matter?
writ petition.
The first writ petition in the list, my lords, today, 23 of 2016. I'm for the second petitioner, Ms. Anjali Sharma.
Yeah.
And my learned friend wanted to point out that he is also there after me, my lords.
Far as I am concerned, my lord, I do not represent the Tamil Nadu matter at all. My lord, I am really not concerned with Jallikattu.
That's it. So
I am concerned with Maharashtra, which is entirely different.
That's right. Let them.
Points are different. So I am waiting that if Tamil Nadu is over, they'll have.
That's right. So he's the last person we are going to permit him from Tamil Nadu. We have had enough from Tamil Nadu. we have had spent time enough time.
I bow down, my lords, I understand.
So in your case also, you will limit your this time.
I'm going to try, my lords, to limit myself.
What we are going to do is.
I'm only going to make arguments that your lordships have not heard till now.
He is the second, representing the second petitioner.
Petitioner in a petition which is already argued.
It's not been argued, my lords.
You argued for the first petitioner.
Nobody argued.
What is your?
Because they are not now willing to join.
Oh.
Animal Welfare Board of India has backed out,
Oh,
which should tell your lordship something about what is involved in this matter, is my respectful submission. That is after having been the, my lords,
What is the number? Kindly give us, please.
writ petition 23 of 2016. I am for the second petitioner, Anjali Sharma,
No,
who is
that's
a
not
former
only-
member.
They are not prosecuting.
Is it 2000? So as far as they are concerned, they'll have to be different. First petitioner is concerned, the petition will, they are not pressing it.
They
obviously.
are not pressing it, my lords. I'm correct on that.
Yes, go ahead, go ahead.
Only a minute. In this verification, we have also filed for intervention.
We'll consider hearing you. Let us see. If it is necessary, we'll hear you.
There are you.
Yes, go ahead, go ahead. So I'm going to say from 4 to 3, we are going to see. 1 hour we are going to see next one. 1 hour.
This is, give me the file.
Yes, I am going to be making two main submissions. First is, there is no legislative competence
Yes, no legislative competence.
to pass this amendment
Yes,
at all.
yes.
To the extent under this, to the extent that it is. my lords. First, I told your lordships is there's no legislative competence. Under that, I wanted to submit that A, to the extent that this law cannot be traced to entry 17 of list 3.
Yes, yes.
To the extent that it cannot be traced to entry 17 of list 3 or to any other entry in list 3, presidential assent is immaterial and cannot save this Amendment Act. First proposition. Second proposition is it cannot be traced also to entry 15, either 14 or 15 of list 2.
14 or 15 on list 2.
Yes. And therefore, for these two reasons, there is no legislative competence.
Not fine.
Yes. And consequently, at best, it can fall under list 1's residuary entry, as fell from my lord the other day, and no other. Whether Parliament, my lords, your lordships had asked the question, whether Parliament,
Just tell us what elaborated and
whether Parliament will pass the amendment or not, I don't know.
Yeah.
But at that stage, we look at the parliamentary amendment is my respectful submission. Now, my lords, let me explain why I say it cannot be traced to entry 17 of list 3.
yes.
My lords, when the original law was passed in 2009, the Tamil Nadu Regulation of Jallikattu Act, it could have been argued that because it sought to regulate Jallikattu, which may cause cruelty to animals, therefore it's a law which is traceable to prevention of cruelty to animals.
Correct.
But the moment Justice Radhakrishnan, His Lordship Justice Radhakrishnan, renders a finding of fact that it is necessarily cruel to the bull to make it engage in this particular form of exhibition, performance, sport, whatever you call it. The moment this finding was rendered, any law which now seeks, my lords, to allow Jallikattu, to permit Jallikattu by allegedly making it more palatable, by making it less cruel, whatever you call it, is no longer traceable to this entry. The entry is not, and this is my respectful submission, the entry is not cruelty to animals. The entry is not performance, exhibitions, etc. of animals or competitions involving animals and or humans. The entry is prevention of cruelty to animals in entry 17 of list 3. Therefore, by definition, my lords, in my respectful submission, the pith and substance of this act and the rules, assuming that the rules are grandfathered into the act about which there is some, my lords, lifted into the act, in my respectful submission, this can never in pith and substance be relatable to entry 17 of list 3. Then, my lords, the next limb is that the entry 14 and 15, when one looks at the pith and substance, it is not related to agriculture, animal husbandry, etc. It is not related to protection, preservation, improvement of stock or veterinary practices or whatever.
So, Venugopal, see, isn't it not better that now you have ticked it off? Basically, you have flagged the issue. Depending on how they are going to defend it, you can elaborate it at that stage. Why we are saying it, now they have to meet it. You have argued it. So we'll call upon them to meet it.
My lords, I do want to substantiate it, my lords. I want to cite a couple of cases, show your lordships how the act has to be analysed, how it has to be treated, so that he can meet it in full, my lords.
You can just give the citation so that.
No, I want to just analyse it for my lords so that your lordships see that what I'm saying that in pith and substance, it's not a law which is relatable to these two entries is made out.
According to you, the entry would have been perpetration of cruelty to animals.
Well, that is what His Lordship Justice Nariman has framed as the first question. If your Lordship kindly sees the questions, my lords, that were framed for placing before my learned friend, Mr. Dwivedi had said that nobody has argued lack of legislative competence. I'm afraid that may not be correct. He may not have read my amended writ, is my respectful submission. We have raised these issues squarely, my lords, in our grounds.
Okay.
So, if your Lordship sees the reference, the very first question is the Tamil Nadu Amendment Act referable in pith and substance to entry 17 list 3 of the 7th schedule to the Constitution of India, or does it further and perpetuate cruelty to animals? And can it therefore be said to be a measure of prevention of cruelty to animals? Is it colorable legislation which does not relate to any entry in the state list or entry 17 of the concurrent list? So this is squarely framed and before my lords, and I'm going to try to make that case good. And I won't take very long, my lords. I recognize that when your lordships meet in a configuration of 5, that your lordship's time is even more valuable than normal minutes. But
So which are the decisions you want to tell us?
the first decision which I want to cite, my lords, is State of Rajasthan versus G. Chawla,
Citation.
1959, Supplement 3, SCR 904. I find this decision, my lords, to be is a 1959 Supplement 3, SCR 904.
Supplementary SCR.
Yeah, 3 SCR.
3 SCR.
I find it to be the most useful to understand, my lords.
Page.
90.
At 908 onwards, but I want to place it, my lords, so that your lordships understand
908.
submission.
We would.
State of Rajasthan versus G. Chawla. Because case has to be applied, my lords.
Is it 904 or 908?
904 at 908, my lords. Is where I want to read it out to your lordships, just
So
to
if you
explain.
would, we would request you to allow us to go through that. We will undoubtedly go through that.
No, my lords,
Suppose
with
the-
respect, my lords.
Otherwise,
I am going to seek an opportunity, my lords, to place my case. I won't take very long, but I have to place my case, my lords.
you have cited the judgment and the point also you have very clearly articulated so that you.
I bow down, my lords,
Because of
but
the possible.
I am
time,
told-
today
I am
what we
told
intend to do. We'll
that in the old days, Mr. Settlevar used to put one hand in his coat pocket, my lords, and state propositions to your lordships in 5 minutes to 10 minutes, and sometimes 15 minutes, and then say, that's it and leave. And your lordships would say that's more than enough from Mr. Settlevar. But I know Settlevar, my lords, I need to explain my case and make it out a little bit, my lords. That's my respectful submission. So let me please place these judgments. I need to place one more judgment also, which I'll give the citation.
What is that?
1997 8 SCC 360, State of
360.
Bihar versus Indian Aluminium.
97.
1997, Volume 8 SCC 360, State of Bihar versus Indian Aluminium. And then after that, I will be citing the two judgments, my lords. The cow slaughter judgments. One is Mirzapur Moti Qureshi and the other is Mohammad Hani Qureshi, the earlier one, to make out only this point that it cannot be traced to entry 15.
Paragraphs of Qureshi.
That, my lords, I'll give my lords tomorrow when we meet.
No, we think, see, what we intend to do is we are going to sit for 1 hour today, extra. So that we will cover up because tomorrow we are having constitution bench.
As well as?
We are having the same bench tomorrow. So we think we can devote time today. We are sitting extra 1 hour unless, you don't want to sit, you don't want to.
Let me finish tomorrow, my lords, is my respectful request.
Then let the Maharashtra lawyer start, and Tamil Nadu, whoever this is there. If you cannot finish it today, we can only.
No, so then your lordship would not hear me at all.
No, we are not saying that. Since you are insisting, we have told you we'll go through your the paragraphs because we have understood your points.
No, you have understood the point, but not, your lordships have not understood the way in which I'm going to articulate that point based on the judgment.
You get an opportunity when the other side replies. Mr.
No, my lords.
That's what you're saying.
No, Mr. Beno, why don't you do it straight?
Very well, let me place the
just,
judgments.
take another 5 minutes or so
Yes.
and just finish that.
It will take a little time.
No, that's okay. Let's not debate on the
First-
time
First,
and then.
yes,
spend
your
time.
lordships are right. First, my lords, let me just show your lordship the Tamil Nadu Act. Let me show my lords the Tamil Nadu Act.
You want
Yes, sir.
Not for Mr. Venugopal alone, but for the others also. We intend to conclude the petitioner side. That's what we intend to do.
It may be a little difficult, Manoj, but let me try. Please see at page 137, Manoj. I just want to show your lordship.
You are entitled to take the 2 minutes break, which, we may need.
Very well.
We'll just come back up. So you'll also get that,
Very well.
idea.